Eventually, issue application item number 1.
Yes, pass over.
Item number 2.
Yeah, item number 1.
Item number 1 you are appearing.
Yes. My lord, unfortunately, I am either
Senior, may I hand over these notes of argument, Your Lordship?
notes of argument.
This is the order. Your Lordship was pleased to direct.
All you are appearing for?
Sir, this is not the item number 1, I guess.
My lord,
This is not the item number 1. I am submitting this notes of argument
In the earlier
matter because Your Lordship was pleased to direct to file the notes of argument within 2 days.
yes, please.
It order.
lordship finds in item number 1, my name appears as the petitioner. That is item number 11 and 12. I am neither the
11 and 12.
Pardon?
GA number 11 and 12.
item number 1.
Item number 1.
In GA 11 and GA 12,
Yes.
this happens to be an application made by the Board of Work. Now, why my name
For the
appears?
first time.
Pardon, my lord?
It is appearing for the
No.
first time.
No. My lord,
Affidavits were directed to be filed.
no, my lord. This is an application, my lord, I am coming to.
Addition of party.
It is an application for addition of party in a suit which has already been decreed. And a scheme has been framed by this honorable court.
Whose application?
My Lord, I am appearing for GA number 5 to 9.
Those matters.
My Lord, those
The
matters are
application is
still
this
pending. Those
No,
matters.
GA application is whose application? GA 11, GA 12. 11 and 12. This is appearing.
11 and 12.
11 and 12 happens to be filed by the Board of Alcoff.
Who is appearing?
And in the back sheet, it's Syed Nazmul Hussain.
Anyway, let it be passed over or not today.
No, my lord, not only one thing. My lord, there are, my lord, your lordship will kindly see. My lord, all these applications are up to 12.
Yes.
All these applications are coming, are arising out of GA number 4 of 2023, filed by me. GA number 4 of 2023. Lordship will kindly see.
For the applicant's
And this is the order.
required.
My lord, in GA number 4.
Applicant's presence is required. Applicant is not present.
Yes.
So let it be not today.
My Lord, what I respectfully submit, we have filed, my clients have filed GA 5 to 9. That is also addition of party. Now, directions for affidavits are already given and affidavits are exchanged. Now, what I must respectfully submit, my Lord,
Both in GA 11 and 12 also.
no, up to 5 to 9.
So
All-
are they appearing in the list?
Yes, no, today this is not appearing.
So let it
All
appear
these
in the
matters,
My lord, our joint appeal will be that all these applications are arising out of GA number 4 of 2023, which is not appearing today.
That is, no,
Which is
today,
not appearing today.
taking item 1 and 2,
One.
the other GAs are not appearing.
Not My lord, let all the GAs appear, my lord, together, including with 11 and 12.
Yes. On it, advocate for the opposite parties are present. On appears for the applicant. Of 2024 and GA 12 of 2024. Submitted by the learned advocate for the parties. At GA 11 of 2024 and GA 12 of 2024. We had analogously with GA 5 of 2024 of 2024.
GA 4 to 20,
4 to 12.
up to this.
He appear
5 of 2024 এরম করে করে GA 10 of 2010 of 2024 be listed for analogous hearing on
My lord, let it on next Tuesday.
17/6.
my Lord, 17
17.
have some difficulty.
My lord, I pray, my lord, all these matters, my lord, there are number of lawyers.
17/6. Let it be then appear on 19/6.
19.
At 2 p.m., my lord?
Yes.
At
In the chamber. it will
Chamber,
be taken in the
Okay.
chamber.
All right.
So interior,
Yes,
the other
yes,
side
I will.
applicant
Lordship.
for the applicant.
19.
Grateful.
Sorry.
Item number 3.
I'm for the petitioner, my lord. My application for preliminary decree, my lord. My lord, may I file the affidavit in opposition, my lord? Yes, my lord. My lord, Mr. Swarnendu Ghosh, senior advocate, is appearing in this matter and he wants to argue the matter, my lord. May I file my opposition, my lord, and my lord kindly keeps the matter.
Whose application is this? GA23?
Is my application for preliminary decree, my lord. I am filing, my lord.
Yes, please give the opposition.
Op- But I have filed my replies, my lord. My lord, I am led by Mr. Swarnendu Ghosh, senior advocate, my lord. My lord, kindly keep the matter in the next week, my lord.
Learned advocates for the parties are present. Let the affidavits filed be kept with the record. Let this matter appear on 12/6/2025 under the heading adjourn motion.
Adjourn chamber application.
Adjourn chamber application.
Can it be on 19th if it is not going to my
19/6/2025 under the heading adjourn chamber
Adjourn.
application.
Grateful to your lordship.
petition?
Yes. GA13.
Sorry, side change করতে হবে না? My lord, partition suit, your lordship will find filed in 2009. My lord, I am representing, my lord, the heirs of the original defendant number 1. Now, the original defendant number 1, my lord, was not served with the writ of summons. Ultimately, my lord, application was made by my client, my lord, for dismissal of the suit for non-service of the writ of summons. They had made an application for, my lord, extension of time, my lord, to file the
Writ of summons.
yes, to file the writ of summons. Now, in that, an order was passed. Thereafter, my lord, the original defendant number 1, my lord, she was an old lady. She did not or could not file the written statement, though it was affirmed by her. Ultimately, my lord,
You are
she
representing
One-
defendant of 1A to 1D.
1A to 1. My lord, this is an application for,
Was not filed by the original defendant.
it was not filed by the original defendant. Thereafter, my lord, substitution took place. And your lordship's order and my lord, previous order is also there, my lord, so that my lord, they serve us with my lord, copy of the amended plaint. That was not done. In any event, my lord, I was praying for leave to my lord, file my lord order.
My lord, I am opposing this application only on the ground, my lord, what my learned senior friend said, my lord.
Then you file your opposition.
I will file my opposition.
Yes, Mr.
Ready হবে, কি লাভ হবে?
Learned advocate for the petitioner defendant number 1A to 1D is present. But Mr. Mitro, as learned advocate appearing for, you are for the plaintiff.
I am for the plaintiff.
Plaintiff submits that he intends to use an affidavit. That affidavit in opposition by 16/6/2025 to 16/6. Reply if any by 18/6. I'm keeping it on 19th. On the other matter which I fixed on 19th.
Very well.
Let this matter
Better
appear on
আপনি এই ঘরেই থাকবেন
19/6/2025
Lordship.
under the heading adjourn
Adjourn
chamber
chamber.
application.
Grateful. I would. দিনে করে দিন।
My lord, it's my application, my lord, on the same, my lord, prayer as it was based on a different matter. My lord, the writ of, my lord, it's a suit, my lord, of
Your
2010.
application by.
My application, I'm the defendant, my lord.
For
The extension of time, my lord,
So
to
you want
file
to
the
use your
written statement.
affidavit?
Yes, your lord.
Learned advocate for the petitioner defendant number.
I'm the all defendant.
Advocate for the petitioner defendant.
Both the
is
defendants, my
present. Defendant is present. Our learned advocate for the parties, as the learned advocate for the opposite party intends to use an affidavit. Let the opposition take filed by 16/6/2025, reply if any by
Same.
18/6/2025. Let this matter appear on 19/6/2025. At the heading adjournment.
The opposition হবে আর কি reply হবে এটা যা দেবে দিক
Item number 6.
organize
Pay for the plaintiff, my lords.
Yes.
There's a stay pending in the appeal court in this matter, my
GA3,
lords.
whose application?
In this matter, my lords, there's a stay pending in the appeal court. That's
No, GA3, you are for the plaintiff,
my lords.
plaintiff degree holder.
Decree holder, my lords.
No, whose application is this GA3?
G3, my lords have to take inspection. So I'm not briefed in this matter, my lords. As
Okay, then
senior
not today.
interest. My lords. Great.
I'm making it not today. Let him come ready on the next day.
Item number 7.
Pass it over.
Item number 8.
Item 8.
to 11.
Yes.
No, that's analogous matters. I appear for the respondent number 6, Ashok Kumar Chawla.
8
Yes,
to
ma-
11.
8 to 11, my lord. Raghumal Lakwani.
Yes, so
Yes.
GA applications are to be taken up.
Yes, for the petitioners, I am for the respondent. I have only one submission to make, your lordship.
They're appearing for the petitioner.
My lord, I think they are appearing for.
And whose applications are this? GA 14 and no.
My lord, they are only.
Your
Our
application.
application, yes, your lord.
Yes.
Yes.
My lord, only one thing, my lord, the respondent number 6, that is, your lordship kindly sees Ashok Kumar Chawla. My lord, he expired on 2nd of May 2025.
Question is, these applications are for what? What relief is claimed in this
My lord,
application?
My lord, as far as my lord, my information goes, the relief that he claims here
Yes.
is, my lord, these are the applications made by, my lord, the caveators or the caveatrix, who, my lord, had supposedly arrived at a settlement with the propounder of the will or with the, my lord, executrix of the will. Be that as it may,
The executor,
Your lordship, I am for the petitioner herein.
intervener.
no, not intervener, my lord, they are the caveatrix or the caveators who allegedly had entered into an agreement for consent. My lord, here we say that we have purchased 12.5 bighas of land, my lord, of the total estate of the will, which cannot be probated. There has been an order passed by this honorable court, my lord Justice Krishna Rao, which was affirmed by the division bench as well as affirmed by the SLP Supreme Court.
This application is to be heard on affidavits.
Yes, on affidavits, my lord.
All these applications.
Yes. And my lord, that is there. And my lord, my respondent number 6 also needs to be, my lord, substituted.
The executor has to take steps.
Yes, my lord. I will inform. I'll forward a certificate. My lord, I have received the certificate of death, my lord, for the respondent number 6.
Number 6.
6, my lord, kindly sees Ashok Kumar Chawla. My lord, he expired on 2nd of May 2025.
Learned advocate for the
My lord, I'm handing over a copy of the death certificate to my learned friend for taking step.
advocate for the caveators.
I appear for the petitioner, plaintiff, in the testimony suit.
Executor.
I'm the executor, my lord. It's an LA proceeding. I'm petitioner
Learned advocate,
for the petitioner.
the petitioners and learned advocate representing
I was appearing for the applicant.
the
For this-
applicant in GA 14.
সবকটাতে নাকি একটাতে?
Well, I am appearing in GA 15, my lord.
GA 14, whose application is this?
I think Mr. Shayok also was appearing.
But all the applications are same, on the same.
I can move, my lord, that application. Lord,
Learned advocate for the petitioner and learned advocate for the applicant in GA 15 of 2025. Anyway, all the applications, GA 14,
Because death has to be recorded. here.
GA 16 and GA 14, 15, 16 and 17. All the applicants are present. The applicant,
Respondent.
learned advocate
Respondent.
for, you are for the purchaser.
No, my lord. Yes, I am for the purchaser. My bona fide purchaser, my lord. Respondent number 6.
You are the applicant intervener.
No, I'm not the intervener. I have been added by this honorable court. I have been
Learned
added.
advocate for the purchaser of the
My lord, defendant 6. My lord,
Defendant number 6.
defendant
the
number.
opposite party number 6
Okay.
is also present. As these applications are to be decided on affidavits,
Yes.
an affidavit in opposition be filed by 6/2025, reply if any,
My lord, not 16, my lord. My lord,
Okay.
if it could be 1 week.
17/6/2020,
No, 1 week.
23/6/2025, reply if any, by 30/6/2025. Let this matter appear on P7/2025 under the heading adjourned chamber application.
My lord, one more indulgence, my lord. Two pending applications are not in the list. GA 12 and GA 13 have already been filed. They're pending. There were affidavit directions also passed from my learned friend. Could they appear in the list on the same day?
GA 12 of
And 13, 12 and 13,
2025.
20,
2025, 5.
24, 24, my lord.
GA 12 of 2024.
24.
GA 13 of 2024 be listed on the same day.
On the same date, my lord, if
My
a
lord,
direct,
kindly record the, my lord, the
You
date
have
of the,
dates, yes.
yes.
Learned advocate for the
Number 6.
6 has filed the death certificate of his client. Let the same be kept with the record and let necessary steps be taken.
My lord, I have handed over a copy of the same to my learned friend as well. Let that be recorded, your lordship.
Have to be provided by
yes,
the advocate.
Yes, I'll do that.
I have recorded that let necessary steps be taken.
Yes.
we'll write to them.
We'll
Yes.
write to them,
Yes,
the
yes,
plaintiff will write.
My lord,
Your
one
lordship kindly record that the death certificate has been handed over to my learned friend.
Handed over to the learned advocates
Hmm.
representing the parties in court.
Deeply obliged.
My lord, I'm sorry, my lord, one more indulgence. GA 12 and 13 affidavit directions have already been passed. It hasn't been completed.
My lord,
My
we'll
lord,
file it.
yes, my lord,
We'll
can
file
record
all the
that.
affidavits
Let
together.
readings be completed in GA.
I've directed to be listed on the same day.
Yes.
That is on 3rd of July.
3rd of July.
Oblige.
Deeply obliged, your lordship.
I would say opposite party number 6.
Deeply obliged, your lordship.
Item number 12,
Yes. Pass over.
item number 13,
Your lordship, my senior learned advocate, Mr. Patil Saratha, is making his humble submission for court.
Okay, not today.
Much
item
obliged.
number 14,
Pass over. Item 14.
Yes, your lordship. I am for
Yes.
the petitioner, my lord. This is an execution application, your lordship. On the last occasion, if your lordship recollects,
I appear for one of the parties to the present proceeding, and I am.
your lordship, he is the third party, my lord.
For
Judgment data.
No, I'm not
He's
the
not the
judgment.
judgment. He is
I
the
am in
third party.
occupation of the suit premises. Now, my lord, in the execution application,
My lord, may I start, my lord, since I'm the decree holder, your lordship. There's an execution application, my lord, and there are for a suit for eviction, your lordship. GA5 is an application that I have filed because in the decree there was a direction for appointment of the officers, special officers, for the purposes of determining mean profits. Mean profits were determined. I had filed an application wherein it was directed that the determination of
Handed
the
over to you.
possession is not handed over to me.
Possession
There was
is
a
not-
direction for the possession to be handed over. That is when an application was filed by the intervener under Order 22, Rule 99, my lord. Now, my lord, what had happened is the mean profits have been treated to be part of the judgment and decree, which is why we had to come up with the present application, that is GA5, which is in your lordship's list. GA5, my lord, only what I am seeking today is disclosure of affidavit of assets by the judgment debtor. That is all that I'm seeking. I'm not seeking dispossession.
Your lordship, I'm representing judgment. Your lordship, my senior is engaged in another court. Lordship, kindly short passover can be granted in.
We are making it not today then.
My lord, pass over then. Your lordship recollects on the last occasion also, as a last chance, your lordship had given them adjournment, my lord.
presently I am in occupation of the suit property.
That's a separate application. If you are in occupation, if you have filed an application, that can be considered.
On this one, the new application that is there on board, that is GA5.
Yes.
A copy of the application.
That cannot be.
That has
That
nothing
cannot
to
be.
do with
Yes,
your
your lordship.
occupancy. Okay, that is with regard to the suit
If any
property.
order is stayed,
Anyway, you see, that is upon the judgment data. You don't have to comply the decree. The decree of mean profit
yes, that's
is not to be complied. So
but I am only on this, my lord. If any order is straightforward.
order is passed with regard to the handing over of the suit property. You may be aggrieved to some extent.
Yes.
But not with regards to mean profits, my
So
lord.
for mean profit is concerned,
The application is only restricted to the mean profit.
Definitely,
then I
it's a
do
mean
not have any
profit.
objection. But if there are other prayers in the application relating to possession of the immovable property, then my lord, I will be aggrieved.
My lord, in any event, he is a third party.
Because
This is the applications that has been filed. If the other applications are to be considered, they are only aggrieved by with regards to the possession because they claim to be in possession. Now, with regards to mean profit, only mean profit, your lordship. And what I'm seeking is, it is like a money claim. So I'm seeking now disclosure of affidavit of assets, which will not prejudice either of the parties. Whether they,
Lordship, one indulgence, if kindly Lordship makes it not today.
no, your lordship, it is as a last chance. I'll.
As a learned advocate for the judgment data, prays for an accommodation. Let this matter appear on
Your lordship,
12/6/2025 at the top of the list. No further adjournment will be granted.
As your lordship.
grateful, your lordship. 12. Your lordship, may the last chance that is regarding in the list, my lord, it is noted, may that also continue on the next
Yes,
occasion.
that
It
will
is
be there. I have
yes.
made it clear, no further adjournment.
Grateful, your
Because I am for the decree holder, my execution application, seeking execution of a compromise decree.
The J1 for
J1 filed by them challenging the validity of the decree, my lord. It was moved by Mr. Shakur Sen before the vacation, my lord, if your lordship will recall. He moved his application, my lord, for 45 minutes.
want adjournment today?
No, my lords. He's out of station, my lords. My lords, the GA1 is pending since 2020. My lords, kindly see. Now, my lords, by an order dated 27th March 2025, a coordinate. No one has talked to me, my lords. No, my lords, this is a misleading fact. He got the matter fixed. My lords, may kindly take the last order. My lords, may kindly take the last order. Kindly take the last order. Mr. Sen has commenced his argument on the application but could not complete the same.
J1.
Yes, my lords, 15th May. And my lords, today he is not here. Now, my lords, I will not stand in the way of the adjournment, my lords, because he's a senior advocate, may be occupied, my lords, somewhere else. He may have other pressing issues. Now, my lords, but my grievances need to be taken care of. Now, my lords, by an order dated 27th February 2025, though, please. Let me kindly see. Mr. Sen has commenced his argument on the application, but could not complete the same. Now, let me take one more order, 27th February 2025, passed by a coordinate bench of this honorable court, my lords. My lords, if I may just place, this is an application under section 47. Mr. Tiwari, kindly. Someone is making submissions. Don't. No, it is not your application. It is my execution application. Please don't act smart.
J1 is my application.
Don't intrude court proceedings. Please don't intrude court proceedings.
Anyway, let us stop this
Yeah,
dispute.
my lord.
Let it appear day after
No,
tomorrow.
my lords, kindly
What
just.
order you are seeking?
I am just seeking affidavit of assets. My lords, may kindly see.
It will pass in
No,
presence of Mr.
my
Sen.
lords, my lords, may kindly appreciate one order, my lords. 27th February, your lordship will take. Kindly take. My lords, I'm just showing. I am 27th.
Affidavits are already complete.
No, my lords, that is the GA. That is the GA, my lords. My lords, kindly take.
GA application.
No, my lords, the
No,
court,
no,
this.
as is the hearing of this application has commenced, let it be concluded.
I appreciate, my lords. But, my lords, while it was pending also, this honorable court passed an order of injunction, which is, my lords, 27th February 25. My lords, kindly see.
That is
To-
continuing.
No, my lords, but,
Or do you want extension of that?
my lords, I want extension of
Yes,
that.
please let
One
it
more
happen.
thing, my lords, kindly appreciate. My lords, I have been protected to the extent of 23 crores. Now, my lords,
What was the order?
my lords, kindly, that is why I am saying, my lords, kindly take 27th February. My lords, I'll just place it for your lordship. This is an application under 47 of CPC. Challenge the executability. My lords, court has recorded. First paragraph, my lords. Kindly take first paragraph. Where judgment data has challenged the executability of the consent decree. This was recorded. In course of submission, Mr. Sen at the outset draws that 6th February, with this court passed an order of injunction restraining the judgment data from operating in bank accounts, leaving apart some as mentioned in the said order.
Which order that was?
My lord, 6th February though. Because may kindly take this very relevant order, my lord.
Yes, February, yes.
Because on perusal of the entire papers as placed before this court, it appears GA1 is basically an application under 47, where judgment raised the question of executability of a compromise decree on 14th March. It is made known to this court that exchange of affidavits is complete with regard to GA1. On behalf of judgment debtor, my lord, similar situation had occurred and accommodation has been sought for. Prayer for accommodation is opposed. It is submitted. Judgment data has miserably failed and neglected to comply with the terms of settlement for which instant case has been filed. There is urgent necessity for protecting interest by passing appropriate order on perusal, my lords, on entire material. After giving due consideration, this court is inclined to allow prayer. However, my lords, in order to secure the interest of the decree holder, let there be an order of injunction upon judgment debtors from dealing or transferring properties which are mentioned, my lords. Thereafter, my lords, may kindly turn over. The judgment debtors are further restrained by an order of injunction on operating bank accounts. Now, my lords, these are not the bank accounts. Now, my lords, that is why I am seeking an asset be filed. My lords, I have an award.
order is passed, okay.
Yes.
When an order is passed, let that continue.
No,
Let
this,
that-
this
it
is
still
continuing.
continuing.
No, it is still the last day of June, Maloj. It is still continuing. Now the assets, Maloj, without the assets, Maloj, how will I know? How will I recover? Maloj, and 2020 execution, Maloj. 25 years have passed. Maloj, Supreme Court in Rahul Eshai is saying, Maloj, 1 year, 6 months money decree, Maloj.
Anyway, on the next day, I shall definitely consider learned advocates for the degree holder is present,
Maloj, may record my prayer, Maloj, just then.
for the degree holder submits. And with the direction for filing a affidavit of assets. We have made on behalf of Mr. Kuchen, learned senior advocate representing the judgment debtors. Of justice, the prayer is allowed. On well, let it be on next
Yes, 12 is fine.
17/6/2025 under the heading adjourned chamber application.
The same, it may retain its position.
Actually, adjourned chamber application, same position.
And Maloj, one thing, the interim order be made absolute. Absolute is till only June. Maloj, why? Maloj, they have not opposed, they have not filed. any
Interim order dated 6th February 2025, which is continuing, shall continue
Till the disposal of the execution application, Maloj. Till the disposal, Maloj, they're just protected.
till 18/7/2025.
Very well, Maloj. Very well. Deeply. Maloj, it is. Maloj, in Rahulesh, I'm so excited. 5 years he's sitting, 5 years he's sitting tight over the matter. Maloj, this is the reason our courts are, because of such people, Maloj, there is bad name, Maloj.
He started
5 years, Maloj.
This matter will appear on 17/6.
Yes, Maloj.
Interim order to continue.
18/7.
That is 18/7.
Deeply obliged, Maloj. Maloj, 5 years have passed, Maloj. Compromise decree, they have agreed that they owe me money. Maloj, and mine, yes.
You have waited for 5 years, wait for 5 years.
Maloj,
No, Maloj, kindly appreciate, Maloj, this court has entertained my.
please, Maloj, see, after 5 years, order of injunction was passed, Maloj, on 26th.
Necessary orders will be passed.
He won't order today.
Deeply obliged, Maloj. I am deeply obliged.
Item number 16.
I am appearing for the decree holder, Mala. I am praying some time because we have to receive instruction, Mala, from client, Mala.
Not this week.
Not 2 weeks, Mala. And
Prayer of learned advocate. The matter stands adjourned till 24/6/2025.
the next matter also, Mala. 16 and 17, Mala.
17 also same.
Yes, ma'am.
To the decree holder in the matter, GA2 is judgment letter 2's application. I'm led by Sonal Sharma.
A2 is judgment debtors application.
2, judgment letter number 2's application,
Okay.
which is listed today.
You are opposing this application.
Yes, Lordship. The decree holder.
Either pass over or not today. Okay, I'm making it not today. You are led by?
Sonal Shah, Advocate Sonal Shah.
Okay, not today.
19.
19, my lord.
My lord, Mr.
I am
Somin
the Commissioner of Partition, my lord, in this matter, my lord.
Yes, you are for?
I'm for the decree holder. Mr. Somin Dott is appearing. I'm seeking for a short passover.
Both parties are not present. The judgment debtors are also not present.
Earlier occasion also judgment.
Later was not.
I'm, my lord, representing as a Commissioner of Partition, my lord, as awarded by this honorable court. Since last
Pass it over for 15. Pass over in the first one. Pass over. Yes, item 20.
Yes. Item number 20, I am appearing on behalf of the decree holder.
You are appearing?
Decree holder. Input is withdrawn. The matter has been settled.
20.
20.
You are for the decree holder. So, what is the position of this execution case? What is the present position of the execution case?
Settled down. Yes, it's been settled down.
It is in the verge of settlement or settlement already arrived at?
Settlement done.
Settlement has been.
Between the parties.
Is there any terms of settlement? Anyway, I'm making it not today. Come with the instructions.
Settlement letter has been already given under the
Settlement letter given.
settlement agreement.
Agreement is filed in court.
Yes. Last orderটাতেই ছিল
Of assets is filed. There is no
Sir, mention
terms of
the-
settlement filed in court.
Claim amount has been received. 15 lakhs claim amount received.
The amount of 15 lakh.
15 lakh.
Paragraph 6, it is stated that parties to these terms of settlement further agree that the present execution application would remain adjourned till the judgment debtor makes the entire payment of 14 lakh. According to you, 15 lakh is already received.
15 lakh.
Have you obtained an written instruction from the decree holder that he is willing to withdraw?
I guess
Learned advocate for the decree holder is present and submits that the matter is settled and prays for time to obtain the written instruction to file in this case regarding withdrawal. Let this matter appear on 17/6/2025 under the same heading.
so please the return.
No, 17/6 the matter will appear. You obtain written
Return.
instructions.
Number 21.
I appear for the judgment debtor. Lord, I appear for the award holder. Lord, I pray for a short passover. I've been led by Mr. Deepan Sarkar. He's on.
One short pass over.
Lord, Your Lordship, item 2, I appear for the decree holder. Your Lordship was pleased to appoint a special officer to inquire into the name and addresses of the judgment debtor, Your Lordship. Your Lordship, the special officer had gone as visited, but he was not able to complete the entire exercise. He has
Then item 21.
22, Your Lordship.
Item
My lord, item 22. My lord, I am leading Mr. Singh, my lord. My lord, the issue here was, my lord, this was a partnership firm who had taken advance from me with regard to rental charges. My lord, after that, the partnership firm the property was sold and the amount advanced as rent was supposed to be returned to me. The court had made this finding, and after this finding, my lord, there was a decree passed for recovery of the amount. The partners have not paid and they have left, and service could not be completed. For this purpose, my lord had appointed a receiver and also directed police help.
So what order was passed on the last occasion?
My lord had directed a receiver to be appointed to ascertain their addresses and also directed for police help in case the receiver so requires.
So that is not complete. Report is not yet ready.
No, Your Lordship.
My lord, I believe the report is not yet ready, nor has perhaps, my lord, police help will also be required. For that, necessary steps may be taken because they have been able to ascertain the next of kin of these partners.
I made it clear that necessary police help and help from municipal authorities may also be obtained. It is already there.
Yes, my lord. Yes, my lord, it is there. Yes, my lord, kindly grant that extension.
The holder is present. Learned special officer could not make the report ready in terms of order dated May 6, 2025. However, the time to file the report is extended till 19/6/2025. Let this matter appear on 19/6/2025.
Much obliged, grateful man.
Intimate the special officer.
I should. We should.
Item number 23.
Yes, pass over. Yes, 23.
Not today, Lordship.
Not today.
Case number 24.
24.
Supplementary affidavit filed as per direction.
Order passed on last week.
And last, your lordship, the order was supplementary affidavit is required to be filed.
Copy of the supplementary affidavit is served upon the judgment
Served.
letter.
Served. Ready, sir. Yes. 130. To be sent by mail, it is delivered.
The judgment letters.
But you would recall that old gentleman, his brother, Virendra Singh, lordship, what
Petition, they were represented.
they were represented. So what has happened, lordship? They have lent money, they have received money, both ways. So lordship will see annexure B for a moment, the supplementary affidavit.
No, I'm telling that what I am contending is this. On the last occasion, the judgment letter were represented.
Yes, yes.
So serve them a notice, let it appear day after tomorrow.
We will see.
A learned advocate for the degree holder is present. And appears for the judgment letter. Let this matter appear on 12/6/2025. Learned advocate for the degree holder is requested to intimate the judgment letter.
Yes.
Learned advocate for the degree holder is requested to intimate the learned advocate for the judgment letter by notice.
Five.
Same order.
The same order, 25 will be. Let the supplementary affidavit file be kept with the record.
Deeply ordered.
Case number 26.
My lord, I am appearing for the respondent, the judgment letter in this matter. My lord, my preliminary objection in this particular matter is the fact that the court does not have jurisdiction to entertain the particular proceedings. This was an order passed under the West Bengal Housing Industrial Development Act. My lord, I have taken out an application.
You want? But for the judgment letter.
Yes, my lord.
I am for the judgment letter.
Who is for the degree holder?
My lord, Mr. Gupta is appearing for the degree holder.
Year one is to be
My
heard
lord,
of.
yes,
So
ma'am.
year file your affidavits.
No, Lord, it's being moved today.
Right.
Lord, two things, my lord. If your lordship sees your lordship order, last order. The lordship had granted them time to file their affidavit of assets, my lord. Because the earlier affidavit of assets was not informed, my lord.
My lord, my affidavit of assets are ready. I can file that. In any event, I am filing it. I have no problem with that. I have reaffirmed it in the proper form and I'm filing it today itself, my lord. I have no problem with my lord's direction. Yes, my lord, I'm filing it.
My lord, I will.
But my lord, it cannot proceed.
So
It cannot proceed without hearing this application.
Just indicate one thing, my lord, for GA1.
Yes.
My lord, if your lordship comes to GA1, paragraph 3 onwards.
Yes.
This is the first line of defense, my lord. But albeit the order being passed by Hira
West Bengal HERA, which was constituted under the West Bengal HERA 2017, has been declared ultra-virus and or repealed by the Honorable Supreme Court, reported at such and such. The particular order is not enforceable in law. There has been no approval of the present proceedings under the provisions of RERA. It cannot be considered as transferred and or disposed in accordance with the law by the authority constituted under the RERA Act, my lord. This is their defense. First line of defense, my lord. Now, if your lordship takes my...
No, my lord, this is not my first line of defense, my lord. It is my application. My lord looks at paragraph 5. My main contention is it has to be filed in terms of section rule 25. It is my application, my lord.
For the degree holder and learned advocate for the judgment debtors are present. GA 1 of 2025 is taken up for consideration. Our learned advocates. This matter is required to be heard on affidavits. Let affidavit in opposition be filed by 17 next Tuesday. Reply, if any, by 26
March
20th of June. Let this matter appear on 24/6/2025.
My lord, and
March of this one.
Let the affidavit of assets filed be kept with the record.
And my lord, they have not served it up.
We'll serve, my lord. We'll file it and we'll serve.
Copy will serve.
No, it shall be done within the course of the day. I shall see to that, my lord.
Yes.
Number 27.
Seven,
Well,
my lord.
27, I appear for the decree holder, my lord.
I appear for the respondent, my lord.
Pursuant to my lord's last order, my lord, we have been handed over possession of the first floor.
The report, my lord.
I'm for the judgment regarding the other part of the premises, my lord, where certain equipment was kept, my lord. Mr. Singh had submitted on the last occasion that some permission was required from the authority, my lord. So we've sent the letter to the authority for the permission, my lord. It has been received, yet there is no communication from the authority in this regard.
My lord, I appear for the decree holder, my lord.
Lord, that is at page 6, my lord.
Have you handed over the position of the first floor?
Yes,
First floor, my lord, that has been handed
Mr.
over.
Dotto is leading in the matter. I am for the decree holder. Mr. Dotto is addressing your lordship on that. The first floor.
My lord, first floor has been handed over, but there are certain equipments, my lord, junk machinery which are lying there at the, my lord, first floor, which they have not removed.
I have mentioned, my lord, in my lord. There is unfortunate, my lord. Paragraph 5, my lord. Broken chairs, tables, and some fashion still there, my lord. At the time of position, my lord, and they assured that, my lord, they will clear out that.
Paragraph 5.
Yes, my lord. They assured.
All machines. The first.
Remove. Fashions of the broken chairs and tables. They assured they that they
First floor possession is handed over to the receiver.
I also handle it more.
Degree holders.
My lord, we have received the first floor position.
How many rooms are still under the occupation of the judgment debtor in ground floor?
And some around 8 rooms are there, my lord. Around
In how many rooms? 8 rooms. In 8 rooms. In how many rooms the machineries are kept?
my earlier. I have mentioned, my lord. One room with USD machines.
No. Which paragraph in the earlier report?
Earlier report, my lord, page 4, my lord, paragraph, second paragraph. 8 rooms among those 8 rooms, there was one user USD machine, blood sample collection, and of the rooms are by the doctor chamber.
Now the doctors are not attending the chambers.
That my lord,
Are the doctors attending the chambers now? So far, this USG machine,
they're using
so far, 8 rooms means 3 rooms. One is USG machine, one is blood sample collection, and the other is X-ray. So, with regard to these 3 instruments and these machines, permission may be required to be taken. But whether the other rooms are occupied by doctors,
there were no machine.
so there was no machines, only chairs, tables.
Tables and
But where have you stated that whether there had been still doctors are sitting there or not in those chambers? Where have you stated in your report? Have you stated that?
no, my lord, that I have not, my lord. They told us the doctor was still sitting.
No, you have visited. What time do the doctors sit there?
My lord, let me take instructions and come back, my lord. I am briefed today, my lord, in the matter, my lord. I will take instructions from my client and come back.
May I just say this, Your Lordship? I appear on behalf of the decree holder. The first floor of the building, the possession has been handed over. There are a lot of stuff which is still lying there. What the learned receiver has said, they were supposed to clear out within 2 days. That has not been that has not
First
happened.
floor.
Yes, the first floor. That has not happened. The trash is still lying there. If Your Lordship gives us the permission, since they have not taken it, if Lordship gives us the permission, we can clear out the first floor and let them give us a specific date as to when they will be handing over the rest of the rooms where the machineries are not there. For the machineries, whatever permissions they require, their lordship has been handed over a report. We have not been given a copy of that, Your Lordship. Let them give us a copy, keep it after a week, and give us this liberty to clear out the first floor.
First floor is concerned, some furniture are to be removed.
Yes, Your Lordship. They have not removed it. I am under instructions and submitting that it has not been removed. If Lordship gives us the liberty to remove it, since it's the property of the judgment debtor. That is why I need liberty from Your Lordship.
My lord, first floor, there was no dispute, my lord. We had.
Question is some articles and machine and furniture are there, you have to remove it.
But that we will render assistance, my lord, through them to remove it. My lord, so far as the ground floor is concerned, my lord, that's where the problem is, my lord. We had indicated on the last occasion.
Where is that?
My lord, I had filed an affidavit. My lord, I have filed an affidavit, my lord. If Your Lordship. The original copy of it. My lord, the original affidavit has been submitted before Your Lordship. My lord, may I have?
Affidavit in reply. No, your affidavit with regard to the steps taken.
Yes, my lord, will kindly seize my affidavit, my lord. This
is by Kullan Kumar Ghosh.
Kullan Kumar Ghosh, my lord. Lord, the authorized representative of the defendant in this matter. But will kindly seize page 6 of the affidavit.
Was when on 21.
21st of, like, immediately after the order, my lord, we had taken steps. Because it was a running diagnostic center, my lord. There are equipments which are installed.
So 3 rooms are there. So far the instruments are concerned.
Yes.
The other 5 rooms are only furniture, chairs, and
yes.
table of the doctors. Doctors are not attending now.
Not attending now.
So take steps to vacate those
Very
other
well,
5.
my lord, we'll render assistance, my lord, whatever.
Advocate for the decree holder, petitioner, learned advocate for the judgment taker, and learned receiver are present. Learned receiver files the report. Terms of order dated May 6, 2025. Let the same be kept in the record. Appears from the report that in terms of order dated 5. Position of the first floor of the suit property is handed over to the decree holder. Stop. However, it is submitted by the receiver that some articles are here in the first floor which are to be removed. Stop. Thus, the judgment debtor is granted an opportunity to remove the articles from the first floor and to make it entirely vacant. Stop. On the the affidavit filed by the judgment debtor reflects that the director, that additional director of health services, CE, Health and Family Welfare, Government of West Bengal, been implemented by order dated 21/5/2025 with regard to removal of radio diagnostic equipments. Stop. However, no steps is taken by the additional director of health services within brackets CE. As it appears from the report of the learned receiver that the 3 rooms, the ground floor, there are instruments for diagnosis, but the other 5 rooms, there are no such instruments for medical diagnosis. Stop. Thus, the judgment debtor is granted opportunity to make the 5 rooms vacant where there are no instruments lying for the purpose of diagnosis. The instruments lying for the purpose of diagnosis and pathological tests. Learned receiver shall visit the property within a period of 10 days upon notice to both judgment debtor and the decree holder, and judgment debtors shall within this period of 10 days or within such date to be intimated to the receiver, clear all the 5 rooms which are occupied by some furnitures other than the rooms where the instruments for diagnosis and pathological tests are lying. Learned receiver, upon fixing a date, shall take steps to see that the 5 rooms on the ground floor are vacated and the first floor where some furnitures are lying are also cleared. All necessary access must be provided by the judgment debtor.
Well, regarding the balance rooms also kindly provides for a direction.
With regard to the intimation sent to the additional director of health services, a reminder representation be made by the judgment debtor and a copy of this order be communicated to the said authority for taking decision and necessary steps. Learned receiver shall file a report on 26/6/2025. A petition of 200 GMs be paid to the learned receiver.
Lordship is keeping it written on my lawn.
26th.
Grateful.
But I have served a copy of the affidavit to both my learned friends.
Great.
Item number 28.
Yes.
My lord, this is the execution application, my lord, which the lordship will
Arising
please-
from the same suit which appeared before your lordship yesterday.
28.
28, my lord.
Your lordship.
What is the present stage of this case?
On the
But the trial court, my lord, where when the suit had been decreed, it was directed, my lord, that the plaintiff would vacate the premises within.
Yes, your lordship.
No,
The
no appeal
restoration
is
application,
pending. No
the
appeal is pending as of now.
restoration has been filed, your lordship, as I apprised your lordship yesterday. The restoration application is supposed to appear tomorrow, your lordship.
Before this court.
My lord, your lordship was pleased to fix it on 18th of
Very
June, when the applications in the suit as well as the two applications in the suit are remained.
Appearing in the chamber. The other case is not appearing in the chamber.
No, that is for the mean profit, my lord, for which the application was taken out. This is the execution proceedings. That is not in chamber.
No.
So, my lord,
Your lordship
what I
may
was
be
indicating
served
was,
with
my lord,
this.
this is my execution application, which I may
Yes.
be allowed to make submissions on.
By the learned advocate for the judgment data that the appeal filed against the decree is dismissed for default and restoration. So, in the interest of justice, an opportunity is granted to the judgment data to take necessary orders from the appeal court. Stop. Let this appear on 19/6/2025. Is hereby made clear that in the absence of specific order from the appeal court, no further time will be granted.
Grateful, my lord.
And may this be served upon us, your lordship. It has not yet been served upon us.
Which application?
This execution application has not yet been served upon.
The old decree?
No, that
Your
was the
lordship.
point, my lord.
But your lordship, it had appeared on many occasions. Now it can be served.
Copy of this execution application
My lord, first let them get an order from the appeal court if at all.
Doesn't mean that it cannot
Absolutely,
be
I
served.
will if need be.
Yes, absolutely.
If they want to, my lord, they can.
Yes.
That is something which,
Yes.
very well, my lord, I'm serving it right. Let it be recorded. I'm serving it right here and now.
Application is served upon the learned advocate for the judgment.
Grateful, my lord.
Pursuant to your lordship's order, dated 9th April, my lord, possession has been handed over by the office of the sheriff of Calcutta. Got a copy of.
You're for the decree holder.
I am for the decree.
Report of handing over position.
That I have been given a copy. She will kindly.
I'm recording your submission.
Lordship, kindly.
Learned advocate for the degree holder submits that in terms of order dated 29th April 2025, the possession of the decretal property has been handed over the decree holder, and the decree holder has received the vacant possession. Stop. The facts and circumstances, nothing remains in this case to be decided. Thus, this EC 4 of 2025 stands disposed.
My lord, only if your lordship so pleases, my lord will kindly record the date of handing over the possession. It is stated in the notice.
Possession has been handed over on
17th May, perhaps, my lord. Signature is at the bottom. 19th.
been handed over on 19/5/2020. Let it be kept with the record.
Shall I make a photocopy and
Make a copy and
lodge? করে দিচ্ছি I'm grateful.
May it please your lordship, I am appearing in the matter for.
I am appearing for the decree holder, my lord.
Lord, I am also appearing for the decree holder, but I have, my lord, an application which is IAGA 1 in the execution petition for addition of party. I'll indicate why, my lord. Your lordship kindly takes up the order which is at page 9 to this application. Lord, we appeared for.
We are not opposing, my lordship.
Then, Lord, I'm not making any
I am the
submission.
decree holder. Carriage proceeding is with me. He seeks addition, my lord. He is one of
I'm
my
also the
relatives, my
decree
lord.
holder,
He
my
is also a decree holder. Lordship may allow the application.
Yes, learned
Definitely.
advocates for the decree holder, only decree holder. Is present.
Three decree holders were
All
there.
the three decree holders are present.
Yes.
Application GA1 of 2025 filed by
One of the decree
One of the
holders.
decree holders.
your name.
My lord, we are for defendant number 3,
নামটা বলো
Aditi Mukherjee, my lord.
অদিতি মুখার্জি representing defendant number 3 Aditi Mukherjee moves application GA1 of 2025 for addition of parties. PC
In execution case number 7 of 2025.
number 7 of
My lord.
2025. Heard learned advocates, there is the petition file. There is the learned advocates. That interest of justice allowed. Thus, I allow the petition. Let there be an order in terms of prayer A of the master summons dated 19th May of 2000.
My lord, since it is my petition, the EC is my petition, I think once, my lord, he is implemented as one of the decree holders, the necessary amendment has to be carried out by the decree holders. Lordship will provide for that, otherwise the department may have some confusion.
Let necessary amendments be carried out by the department and a copy be served.
Lord, may we also be permitted.
Main execution was about 1st of July, Lordship. I guess the Supreme Court will still remain closed as on 1st of July. So let it be appear after the court reference.
No, my lord, my lord, we are entitled to money.
Pass any order when to appear.
Lordship had kept it in abeyance, giving them a chance. My lord, vacation bench was there, entire June month it is there.
Not about vacation.
22 crores.
22 crores is outstanding, both of us.
July I shall see.
My lord. It may only be permitted since the
Before the vacation bench on 1st July I shall see.
grateful, my lord. Since I've been permitted, my lord, since I've been added as a party in the proceeding now, may I be permitted to file an additional, my lord, a supplementary affidavit and, my lord, an additional tabular statement. Lord, it's the same reproduction of the same tabular statement, but Lord, it's a consequential prayer, my lord, because I've been added as a party. Affidavit and, my lord, tabular statement.
My tabular statement is there, he gets only
An
one.
additional tabular statement, my lord, only for
Yes, prayed for Mr. Park and additional tabular statement.
additional supplementary affidavit and a tabular statement.
Along with
Tabular statement may create difficulty because that would mean, my lord, another execution.
An additional supplementary affidavit may be filed.
My lord.
Great.
Deeply obliged.
My lord,
Okay,
2 weeks
GA1 of
is
2025
disposed of.
And my lord, the amendment to be carried out within 2 weeks, my lord, kindly provide.
Normally, in the absence of any observation, it is 2 weeks.
But department without it.
In the absence of
Very
any
well.
observation,
If we
it is
have
always 2
difficulty,
weeks.
we'll come back. Very well.
I'm very deeply obliged. madam.
Grateful, madam. Do something.
This mandatory never appear in
GA2.
G2, my lord.
What is this application?
That is their application for setting has been.
Your application.
The mandatory application. And the degree holder, my execution application 514. More than 291. Applicant became infected, may not be partly degree has been satisfied.
Of the degree satisfied.
Yes, sir. But some amount is due that I will proceed that.
Present. And appears for the judgment dated. We move this application. A of 2015
Yes, ma'am. Code number 2918.
within bracket GA 2918 of 2015 is submitted by the advocate of the holder. Part of the decree has been satisfied. And this application GA 2 of 2015 has become effective. The facts and circumstances. GA 2 of 2015 is dismissed as this matter here after giving it after 4 weeks or 6 weeks.
Because the mandate had to appear and they make it part of it.
Let this matter appear on 22/7/2025 for further orders and compliance.
20 seconds.
Item number 12.
My application for production of two documents. The issues have not been framed in the suit. The two documents are two surveys report. One indicating the mean profit, which I would have been entitled to had the premises been vacated by the defendant. And the other is the cost of the repair work that has been undertaken by me. The defendant has filed their written statement, but the issues are yet to be framed. So no prejudice will be caused when this is in furtherance of my claim in the suit for damages.
Well, the suit of 2014. Well, after 10 years, my lord, he.
GA 4 of 2024, are you opposing?
Yes.
Have you filed your opposition?
My lord.
Yes.
Where is that opposition?
The opposition filed, my lord.
Where is the opposition?
The first and foremost thing is that, my lord, there is no such central excise department after promulgation of the central GST Act of in 2017 from 1st July, my lord. They didn't make the, my lord, cost title to be amended properly, my lord. But they are maintaining this application. I'm for the defendant.
I am for the plaintiff.
Well, I've specifically stated in my opposition at, my lord, para 5C, kindly sees, my lord.
5/6, yes.
5C, my lord, 5C.
5C.
Para 5, para C, my lord.
Yes.
I've stated there is no office of 25 Princep Street. After promulgation of Central Goods and Service Tax Act 2017, the Central Excise Department 25 Princep Street, Kolkata was renamed as CGST and CX Holdia Commissionerate. Therefore, unless, my lord, the plaint was properly amended, my lord. My lord, this application.
Which two documents?
The two documents that have been annexed with the application. One is at page.
One report.
One is at page 8.
My lord.
Yes, page.
Page 8 and page 35. These are the two documents that I seek to introduce. Yes.
Page 35.
Page 35. The survey reports. Page 35 is the cost of the repair work. If your lordship takes page 36, that is the caption of the report. Page 36, if your lordship takes. This is the estimated cost of the repair work which I have carried out. This I seek to introduce because my claim is in damages. And page 8 Lordship will take page 9. Page 9 is the report on, is the slightly legible portion on the top, highlighted portion, report on estimation of the rental value of fair market rent of the property. These are the two reports that I seek to introduce.
The suit was for damage. And that this report was, my lord, my learned friend now trying to bring, my lord, after 10 years filing of the suit. And this was unilateral report, my lord, they have procured it.
But if my learned friend is opposing, my lord, this application, then, my lord, may I?
My lord, this will not the judgment of the, my lord, suit, my lord. That's why this application, this.
For the parties are present, are learned advocates on the 4 of April. That this hearing is concluded. We are on 19(6) for orders.
Lordship will kindly consider Order 13, Rule 1 of the CPC. Well, before settlement of
that.
Yes, well, I've pleaded.
My lord, will consider order 7, rule 14, sub rule 3, my lord. My lord, there is no such, my lord, case in the plaint itself. Therefore, this document cannot be relied on by my learned friend, my lord.
But two issues with not with this application, with the suit. That
They have kept it on.
Lordship may pass the order thereafter, my lord.
Number 19.
It's not today. For 19, yes. I am the commissioner of Partition.
I am for the plaintiff decree holder. Here, my lord. That
Everything has been done.
no, my lord. Everything has not been done. I have taken instruction. I was also under the impression that everything has been done, but I have made a chart, my lord, that tabular statement, my lord, clause 3. Tabular statement. Tabular statement. Clause 3, it is the page 3 of the tabular statement, my lord. Kindly see the tabular statement.
Page 3.
My lord, the tabular statement, my lord. Yes, my lord. Page 3, my lord. After that, my lord. Yes.
Roman 3.
There is the, my lord, in the common passage, there is a, my lord, wall. That wall is to be demolished. While we are entering into the premises.
Did you take out any application regarding taking any exception or non-compliance?
No, my lord. The execution application itself is pending before your lordship.
No. Petitioner of Partition has filed the report. According to Mr. Mukherjee, entire thing is done. So you are contending, no, something is yet to be done. So what is that? Have you taken out any application for that?
Or that. Or it is part of the application I am before your lordship. So it's a very small thing, my lord.
Yes.
But kindly see, is necessary police help. My lord has got it, the clause number 3.
Yes.
If any objection such and such, well, leave it, my lord. Thereafter, my lord, by it, third line, my lord, delivery of poison at the time of raising boundary wall and or at the time of breaking the overhead brick wall of common passage. This is the and there is a tin shed, my lord, portion. My lord, while we are entering into the premises, there is a common passage which is covered by tin shed and a common wall, my lord. That wall is required to be, my lord, it is to be open to sky. It's a common passage should not be, my lord, it's a covered one. It should be open to sky. That time when my learned friend, my learned Commissioner of Partition visited, we raised the point. The defendant, they objected to it that no, we can it can be retained. We basically stated that unless this is open to sky, it cannot be give a complete picture so far as the partition is concerned, my lord. Because in future, my lord knows, has vast experience, that point will arise regarding that point itself.
So that is
regarding police help.
So in the at the time of breaking the overhead brick wall of common passage.
This is police help I have paid for, but the purpose is given at the latter part of the paragraph regarding their bound
Entire wall has to be removed, entire tin shed.
tin shade. Well, I visited the premises. It's a common passage over which there is an entrance, there is another entrance. At the other end of the entrance, there is a common wall. And after that, a tin shade is given so that rainwater does not fall on the common passage.
Lord, in that particular place, Lord, there are so many, tenants. Maybe they are tenants, maybe they are not tenants.
What is contained in paragraph 3?
No one is occupying there. It's a common passage.
So far this paragraph
See,
3.
it is their internal arrangement. They may, they all with potential satisfaction. Last time, my lord, I had been there for days together, and we had erected the wall, partition, everything has been done.
The paragraph number 3, that is to be.
That is to be my lord, dismantled. And my lord, my lord, Commissioner of Partition, he should see that the municipal taxes are clear as on date.
Is there any specific order with regard to that?
No, my lord. My lord, kindly give that order. We are ready to pay the municipal taxes.
Cleared.
Main part has been clear.
Main part has been clear. Some portion fractions that is required to be done. That is to be
By the commissioner.
no, madam. Parties will pay. Parties will pay.
Parties have paid.
I have no fund, I have not opened any
It is
account.
not lying with the commissioner.
No, madam.
All along, we will be, if money is falling due, we will be paying it.
According to the
He's a senior solicitor.
But I am the custodian of the original title document and will not both the suit premises as it's just opposite to
My
Calcutta.
lord, give us short direction so that we can come back after 15 days.
Let some inspection be done.
Because my learned friend already is aware of the position.
Yes.
Plaintiff and defendant all are aware.
At present, what step is to be taken by the commissioner?
Mother, he will ask for necessary mason and other persons, laborers. We will be providing that. In his presence, it will be dismantled. Only this much.
Let them try, my lord, if any objection, if any.
I cannot do it. It's under
Then we'll-
for Commission of Partition. I cannot do it. My lord knows it. One line order by your lordship.
Let them clear
that-
out my remuneration, my lord, and the clerk, remuneration of the clerk, my lord.
Mother, remuneration part,
How much you have last paid?
last paid we have all together. Chatta din, chatta.
2,68,000.
2,68,000 we have paid.
For last 16 years, from 2009, my lord.
9.
Yes.
My lord, kindly
Partition
appreciate. My lord,
admission,
kindly let me come back on it because there are certain facts and figures. My lord, will look into it because it's a commission of partition, not a receiver. It's a for a purpose. Is very simple.
For you specify by way of
Yes.
application.
Yes. My lord, which application? My lord, may I?
Make a necessary application if you want something to be done, what the steps are to be taken.
Regarding boundary wall?
Yes,
Yes, my lord, it is part of the application, my lord, itself. It is part of the application, my lord. My lord, kindly appreciate, my lord, a partition cannot be completed. If I raise an objection before your lordship itself, my lord, filing any application further that will linger the proceeding, a litigant, my lord, of 79 years of age, my lord, kindly appreciate this aspect.
Let him take further inspection and let
My lord,
him submit.
he is submitting in open court that is there. He is admitting the fact that the common wall is there and the tin shed is always there. He is admitting the position, my lord.
That should be dismantled.
That should be dismantled, my lord. Kindly one line order that.
Advocate for the degree holder petitioner. Mr. Mukherjee learned advocate commissioner is present in court. It is submitted by the learned commissioner has filed his report. When did you file? Today itself?
No, my lord,
Oh, earlier.
earlier. There are so many reports, my lord, I have filed. I filed 600 pages report. On that report, decree has been passed.
Advocate for the degree holder submits that there is a brick wall.
My
There
lord.
is an overhead brick wall of common passage and a
Tin
tin
shed.
shed above it.
Above it.
Learned advocate submits that the same should be dismantled with the help of labor by the commissioner.
It should be made open to sky.
And it should be made open to sky. During the prayer made in prayer
Madam,
3 of the
12C.
tabular statement,
Madam.
notice of the view
Madam.
that the same should be allowed.
Madam.
Thus, learned commissioner requested to take necessary steps, remove the brick wall of the common passage and the tin shed upon notice to all parties and their learned advocates and fixing dates. The cost of dismantling shall be borne by the parties in accordance with the shares, and a further remuneration of 1,000 GMs be paid to the learned commissioner.
So this will be an ad hoc remuneration, apart from my.
My lord will not make any comment on it. I am humbly requesting.
Additional work, I'm just.
My lord,
I'm
my
just
lord.
giving
My
you
lord will
further
not put in a word because my lord, he is charging remuneration with due respect on monthly basis.
Yes.
My lord,
Yes.
in a
I am the
commissioner
custodian of
partition,
the title
my
deed
lord,
and I'm
in a
custodian of the
in a
property.
receivership,
two-
it is
two
done on a
sequences.
monthly basis.
So the last monthly remuneration paid.
24.
In 2024, 2 lakhs of rupees we have
2
paid.
lakhs are-
Yes, my lord.
So out of total.
Now 5 months is passed, he has not yet been discharged, so just pay 1,000 GM.
Yes, my lord, I will definitely pay. Pursuant to your lordship direction, I am always ready to pay, my lord.
Let this matter
My lord.
appear on 26.
My lord, kindly consider the letter of demand, my lord. So far as my remuneration.
My lord will consider on the next
I've-
occasion.
I've
Yes.
served all the parties, my lord.
I have just waited to, without prejudice, I have directed them. Let this matter appear on 26/6/2025. 26th of June, I am making it. Take necessary steps in the meantime.
I'm deeply obliged, my lord.
But parties have to cooperate. They will do. I will.
You serve a notice and.
I will. Yes, I will.
Because clause 3 also says that the necessary required, he can ask for police help also.
Yes.
My
All parties are directed.
Item number 21.
Well, this is an execution application arising out of a consent decree where we had advanced certain sums of money to the judgment debtor and they had not paid. Now, Lordship, a revised schedule had been drawn up according to which they would be clearing the amounts. Well, they've not adhered to the payment schedule, which is why we came before your Lordship. Lordship had given them one last opportunity to take instructions as to how they will pay. Well, nothing has been forthcoming till date. But I'm praying may one of the directors be asked to appear personally. I believe that will be of some help.
My lord, I appear for the judgment debtor. Lordship, the execution was for a total amount of 14 crores 20 lakhs around. In the last 2 years, 2023, this was instituted, Lordship. In the last 2 years, we have made a payment admittedly of around 9 crores. Now, both parties agree that 4.62 crores is pending. I have just received instructions that.
Were you not present on the last occasion?
My lord, I was present. My lord,
The
I
matter
have.
appeared on May 8th.
My lord, I was.
Passed.
My lord, I've just received instructions that our directors have reached out to the other side and the parties have agreed that a separate proposal may be filed. I've just received oral instructions.
That will take.
My lord, if I'm given just 2 weeks, a fortnight time, and if the matter be kept, if by that time no revised proposal comes, may my learned friends
For the parties are present.
prayer be allowed that time.
Learned advocate for the judgment data submits that we could not obtain necessary instructions. Thus, this matter. 24/6/2025. Advocate shall obtain necessary instructions on the said day.
My lord.
And in the event learned advocate does not receive any report or instruction from judgment data, the director of the judgment data shall be present in court on 24/6/2025.
Grateful, Lordship. Grateful.
না মেনশন করবো। হ্যাঁ আচ্ছা এখানেই বসবেন? আপনি আগে করে দেন।
Yes.
Should be mentioning examination of judgment data.
So it is fixed
One
when?
issue decreed in 2011, 106 questions were put to him. Thereafter, he is evading. Once he was arrested, paid 10 lakhs only out of more than 3 crores.
Okay, let it appear.
My lord, may I be permitted to mention this matter for inclusion in the list, lordship? I have served notice to the other side, but they refuse to accept it, lordship.
Regarding inclusion,
Inclusion in the list, lordship. My lord, kindly see this order, 13th May. These two suits are the suits which have been filed by the defendants. These are returnable on 12th, lordship. And the main suit, that is CS 497 of 1991, which is our suit. My lord, I was praying if your lordship pleases to tag this main suit along with these two suits on 12th.
anyway, let it appear to be mentioned tomorrow.
Great for your lordship.
My lord, may I be permitted to mention a matter for inclusion GA1 and GA2 in PLA number 242?
Yes, give.
Thank you.
Actual motion, item number 51.
In this matter, my lord, I am appearing on behalf of the petitioner. I am the intervener. I being the tenant in respect of room number 27. Yes, your lordship.
Your application.
And before your lordship takes up my application, on the last occasion, 15th of May, your lordship directed us to serve a copy of the affidavit in reply to the plaintiff. So, in compliance with the same, we have supplied the copy to the plaintiff, your lordship.
So, let us take up this application. GA15.
GA15.
You are for the plaintiff.
No, my
Lord, I appear for the joint receiver.
Both of us are appearing for the joint receiver.
But I am for the intervener who is, my lord, holding the possession of the room. I am the sublessee, subtenant by his father, my lord, who is now, my lord, trying to evict me by this process, bypassing the.
This application has been taken out by me being the tenant in respect of room number 27, and at present I am in possession of that room, and I will show it to your lordship that till today I am in possession.
You are not the judgment debtor.
No, your lordship. No, your lordship.
Suit is pending, my lord.
The suit is pending, your lordship.
To be added as a party.
Added as a party, your lordship.
You are the plaintiff.
Receiver.
You are the receiver.
Yes, your lordship.
In the application, if your lordship see, my lord, the master summons, they have prayed for twofold relief.
Yeah.
One is, my lord, the addition of party, and, my lord, simultaneously an order against me, restraining me from creating any hindrance to his, my lord, position
to my peaceful possession of room number 27, your lordship.
So
we are in a possession. It will be very much apparent from my
relief is sought against you.
No, your lordship. No, your lordship.
He is neither, probably, my lord, the plaintiff would have been a better position to, my lord, say, but since, my lord, the relief is also against me, my lord, he is neither a proper nor a necessary party to my understanding. My lord, it is a suit.
I am a proper party as well as a necessary party. I will show you to your lordship.
Declaration and what permanent injunction?
Yes, between the plaintiff and defendant. He says he was, or at all he has a good.
I am a tenant,
he is
your lordship.
a tenant of the property. The tenant cannot be a party in a suit for declaration when the title in between the parties are in question.
Oh, it is not an eviction suit.
No,
your lordship. No, your lordship. Until and unless I be a party to the suit, your lordship, I cannot claim any relief against the learned receivers, your lordship.
You have to be a necessary party,
Yes,
or
your
at best
lordship.
a proper party.
I am a proper party, your lordship.
You are not either of these. You cannot be added.
No, your lordship.
Yes,
I am a.
There is no pleading to that effect in his application that he is either necessary or.
I am a necessary party as well as a proper party, your lordship. I will show it to your lordship. If your lordship kindly grants me the leave to press my application before your lordship.
Please.
Lordship. If your lordship kindly come to the first paragraph of my application, your lordship. The first paragraph of my.
Not appearing because he is the main party, my lord. In the suit, whether he will be added or not, the plaintiff can be.
Plaintiff filed any opposition?
No, your lordship. No, your lordship.
My learned friend has stated that he has served the copy.
Yes, your lordship. It is apparent from my affidavit of service, your lordship. Yes, sir. Yes, your lordship.
In compliance with the same, we have served the copy upon the plaintiff, your lordship.
So last occasion also plaintiff did not appear.
Yes, your lordship.
Mr. Junjunwala is appearing. I think my learned friend has served.
Yes. Served upon that. No. Himmat
to appear. Otherwise, your lordship will reject the matter because the suit is pending.
Himmat Singh.
Okay, record and order. Learned advocate for the applicant, intervener, and learned advocate for the joint receivers are present. None appears for the plaintiff. As this is an application for addition of party and plaintiff's presence is required, let
on 3 occasions, your lordship, we have served copies to the plaintiff, your lordship.
once more till 18/6/2025.
Lordship.
Let the learned advocate for the plaintiff be intimated.
Lordship. We will comply the same, your lordship. Grateful to your lordship. Grateful to your lordship.
But I am for the defendant opposing this application. Let my learned friend places his case.
I appear on behalf of the plaintiff.
And affidavits are complete. It's your application.
Is my application. Now, this is an application for passing the decree as per order of the Partition Commissioner. I have filed this application. He has taken no objection, and again I have filed a reply. Evident reply. This too. I've served these copies to him. Valid. This affidavit in reply and affidavit of service may be taken on record. My lordship, this is a application for partition by meets and bounds.
Yes. Preliminary decree passed.
Preliminary decree passed in 2013. Afterwards, the matter was heard by the Justice Shivkant Prasad, who framed the issues, took evidences, and passed the decree in preliminary form with direction to the Partition Commissioner to partition it by meets and bounds. Now, against which one application by the receiver was filed in 7th April 2017, whereby that against that report, the defendant took certain exceptions. Then first exception is respect of the allotment of the 3rd floor. This is a G+3 storied building. In 3rd floor, all are occupied by the tenant except the 3rd floor, who is occupied by the defendant. Now the question arose that Partition Commissioner gave in the original report, 7th April 2017, 55% to the defendant and 45% to the plaintiff. But he objected, and to the exception, which exception has been disposed of by the Honorable Justice Arindam Mukherjee on 17 December 2019. Now, in that exception, well, his only question was that I want more areas because I live here and my client lives in Delhi. He is now suffering in cancer. That is why that problem. Now, in the open court, before the Justice Arindam Mukherjee, my client agreed that, okay, I am giving you 10% extra. You take the 60%, I am taking 40%. And he agreed in that exception petition that I will take 10% in anywhere from the ground floor or any floor.
December 2019.
Yes, Lordship.
Page 15, that order. Yes. One difficulty Lordship may face, my lord, the first report, which my learned friend said that I took an exception, that failed. That report has not been annexed. Now, without taking that on record, how a final decree could be?
So far, you see, this order is concerned It has reached its finality, 17th
Absolutely.
December 2019.
And that has been complied with. That has been complied with.
Past drawn up expeditiously.
Yes, that has been complied with, that part.
Yes.
Possession has been given in terms of this order. Now he is asking for possession or final decree in respect of other floors. The third floor by this order that has been duly complied with, duly parties have got their possession. There are three other floors. Ground floor.
So Justice Mukherjee's order is concerned.
Fully
it is complied with.
Complied with.
Yes.
Now, with regard to ground, first and second floor, there is a first report, which my learned friend has correctly said that I took exceptions, certain exceptions. That failed, and I did not press final.
That was disposed
of, and that has been recorded in this order. Now, kindly takes up their application. I'm not really standing in the way, but one difficulty is there. Kindly takes up their prayer, page 7.
Yes.
So first prayer is to take the report on record, because the report has to be accepted. Then next, decree be passed in terms of on the basis of the report. Lordship has seen that. Now kindly takes up my affidavit in opposition. This report is the second report. And without the first report, this cannot be acted upon. Kindly comes to my affidavit in opposition. Page 3, paragraph 5. I have said that. My lord has got that? Yes. With reference to, may I, my lord, place it. With reference to the allegations contained in paragraph 7 to 11 of the said petition, say what are matters of record, say what are specifically admitted by me, each and every allegation is denied. No. I say it would be evident from the report dated 7th April 2027, the Commissioner of Partition has directed the southern side of the ground floor of premises number 2, Durga Charan, Dr. Lane. That is the property in question, which has to be, my lord, finally, my lord, partition, would be given to the defendant. Subsequently, the Commissioner of Partition has filed another report. The copies of both the reports, 7th April 2017 and 22nd September 2017, without annexures are annexed here too. That is page 12. Now, if Lordship sees the prayer made in this application is to take on record only the second report. Now, first report without the second report without the first report, my lord, it would be extremely difficult without taking the
first report reached its finality.
First report is
So
not
it
a
has-
partition by meets and bounds.
Correct.
The first report is recorded herein.
If that be so, then
And
the
that
first
is-
report also
that
has
is
to be
only a
taken on
suggestion.
record. Only then the partition in respect of ground first and second floor can be completed. Kindly now sees the some observation made in the first report. Why first report is important? Kindly come to page 24. Everything in detail has been
page 24
of my opposition. I am placing. Page 23, Lordship kindly comes to.
Yes.
Paragraph 17. Lordship has got that?
Yes.
From the valuation report of surveyor, it appears value of each floor has been annexed. Next, ground floor. This is with regard to the ground floor. Then first floor. Then second floor. Entire demarcation has been proposed, and in detail it has been mentioned in paragraph 19. So this has to be taken on record since my objection failed. Now, everything, paragraph 20, 21, 22, Lordship sees the learned partition commissioner has in detail given a proposal how the property has to be.
This is the annexure of the earlier report.
No, this is the first report itself.
Yes, that you have annexed.
I have annexed. They did not. Now, kindly comes to Justice Mukherjee's order. What I respectfully submit, without this second report cannot be taken on record and partition cannot be made.
So first report is annexed by you.
Annexed by me, but the prayer has to be made. If Lordship sees, kindly consider CPC.
And the first exception was only disposed of.
Right.
And first exception failed.
That's right. So the report stands. Now, my lord, unless both the
report is on the record.
Sir, ekটু বলে নিয়ে দুজনে আমি একটু বলতে দিন স্যার.
Okay.
Unless both the reports are taken on record, how could you direct the Commissioner of Partition to finally demarcate?
Now it is in the record. That may be taken.
How
Both
can
the
that be
records
without the
may be
prayer?
taken.
করা যেতে পারে না. There has to be specific
No,
prayer.
no.
That is what I am saying. Now, kindly see Justice Mukherjee's order.
Yes.
17 December.
Yes, page 15.
Page 15. But kindly see, this is a partition suit involving two immovable properties. Lordship has got that. One, two Durgacharan Mitrolen, and the commissioner, and the other one, well, it has been referred to. The commissioner of partition has filed his report separately for each of the properties. The commissioner of partition proposed the third floor of the premises will be divided. This is the report, well, on the basis of which these observations have been made. The commissioner of partition has given adjustment of the 5 less area allotted to the plaintiff in the third floor from the allotment of the defendant elsewhere. The defendant has taken exception to the report. My learned friend was correct in saying that. We too. Subsequently, a dispute cropped up as to who will be enjoying the southern portion of the third floor. The proposal for the plaintiff was that she will take more or less 30% of the third floor if the southern side is allotted to her. The proposal, however, did not materialize, as the defendant being actually occupying, my client is in actual possession, occupying the third floor, residing there, and did not want to leave the southern side of the third floor. The defendant's contention is that the plaintiff stays in Delhi and occasionally visits Kolkata. Since the defendant is actually residing at the third floor, he should be allowed to return southern portion of the third floor. Then, my lord, the exception taken by the defendant commissioner party with regard to the third floor, therefore fails. Third floor. In view of such agreement between the parties in open court, in presence of the respective lawyers, the court passes a decree in respect of third floor, only third floor, to the effect of how it has to be distributed. So this has been complied with, finally. Now, the dispute is ground first and second. Now, kindly see page 17. The commissioner of partition shall once again visit the third floor of the premises, Taltola, and demarcate 60% and 40%. That has been done. They got possession. I also got possession. No dispute. Then, in the event the defendant does not vacate, question does not arise because they have got it. Then, my lord, in terms of the decrees comments, the plaintiff shall get additional areas in the other 3 floors of the said premises number 2. That is the question to be decided, which shall be made by a separate decree that may be passed subsequently. So that decree has to be passed. The commissioner of partition is directed to visit and prepare a further report within 2 months. That is the report which they have prayed to be taken on record. Now, without the first report, how this could be done? That's my point.
So this is the report which the commissioner of partition
in terms of this direction
was directed to submit.
Submit, absolutely, my lord.
That is submitted also.
Submitted, suggesting the allocation of the plaintiff in either of the remaining 3 floors of the premises and submit such report so that the 10% excess area be received by the defendant on the 3rd floor.
So that has to be taken into consideration.
Absolutely. Now, this can only be done when Lordship takes into consideration the first report with this report. That first report, there is no prayer to take it on record. Only on the basis of a second report can a decree be passed when there is existence of the first report. And my challenge failed only with regard to the 3rd floor, to which decree has been fully satisfied. They got it, I also got it. There is no dispute. Now, with regard to the other floor, my objection still today stands, and they have not made any prayer to take that report on record. Can that be done without that? So they have to file a fresh application. Kindly see again the prayer. The report dates.
So far, this is order is concerned, it is confined to 3rd floor.
Absolutely.
How many total number of floors?
4.
4 floors.
4. Ground first and second.
And ground. 3rd floor is settled and disposed.
Absolutely.
Now, in terms of the order,
so you have to pass a separate decree?
Yes, commissioner is visit and prepare further report within 2 months with as to other floor of the premises number 2.
My lord is absolutely correct.
Now my is other 3 floors.
Absolutely. Now my objection was in its entirety. Objection failed with regard to the 3rd floor.
So third
that
floor,
objection has to be taken into consideration again.
So in terms of your exception, which was considered and a further direction was given.
Absolutely.
So what the commissioner did after in terms of this order?
Yes, file another report.
So that has to be considered because when the court has directed him
to
go and file it.
Absolutely. That has
to be complied.
That has to be considered. And the first report also has to be considered. Kindly see this. Kindly read the order again. My objection fails only with regard to the 3rd floor. Page 16. First paragraph. Agreement was with regard to the 3rd floor. My objection failed. I am not disputing that. Now, what will happen to the ground first and second? And there is a
question is whether your exception by way of application was disposed. That is the question. If that was disposed, then there is no scope.
Absolutely.
So what is the order? Your application was GA?
GA9.
Your application, that is exception,
Yes.
was
GA to 133 of 2018.
Now observation is that
1933.
1933 that
But
I have
that-
given in the
No,
epidemic.
if that is disposed, okay. So whatever is there, that has to follow.
that has to be followed.
So
But
what
the
is
question
this?
is that has not been disposed of.
is-
My lord, I have to take instruction from my client, my lord, whether that application has been finally disposed of or not.
No, it will be reflected in the order.
Yes, that has not been done. What has been, my lord, what has been reflected, kindly sees this. My lord, I have to go by the order. Only my exception to the third floor fails.
The decree has passed hearing. We took with
Kindly see, my lord, the first, second paragraph of page 16, the order itself is very clear. Second paragraph, page 16. The exception taken by the defendant to the commissioner's report with regard to the third floor therefore fails. Not the other two floors, other three floors. And decree passed, lordship has seen that only with
third floor fails.
Yes.
And thereafter, upon considering the
Yes.
commissioner's report, subsequent report, and your earlier exception,
and
that to be reconciled.
Yes, Lordship.
That has not been.
Yes.
So your earlier exception with regard to the other floors and the subsequent report of the commissioner.
And the first report, all are to be taken into consideration.
Is your exception, that is the first report?
Yes.
Exception to the first report.
Absolutely.
And the commissioner's subsequent report in terms of this order.
Both has to be considered. That is what I was submitting. And prayer is only to take on record the second report. And
So
kindly
that is
see
second report and your earlier exception.
that prayer is not there. So that has to be considered, of course. And kindly sees order 626, my lord, the provision. Lordship knows, my lord. Order 26, rule 13, my lord, kindly consider. I'm not standing in the way, but there has to be, yes, order 14, order 26, rule 14, kindly sees how the report has to be accepted. Procedure of commissioner, my lord has got it. Kindly see, my lord. The commissioner shall, after such inquiry as may be, divide the property into as many shares as may be.
That is order 26.
Rule 14.
Rule 14.
How the report has to be accepted.
Yes.
Kindly see 1. Then 2, commissioner shall then prepare a report, sign a report which he has done, prepare and sign it. Now 3 kindly comes to that, which applies here, where the court confirms or varies the report or reports, it shall pass a decree in accordance with the same as confirmed or varied. But where the court sets aside the report or the reports, it shall either issue a new commission or make such order. Now the first.
So far, the filing of the report is concerned, that is already done.
Already done. First report.
No, first report is already there. Subsequent, in terms of the order of Justice Mukherjee.
Second report done. But
So-
what I am saying, my exception was with regard to the first report.
So,
in its entirety.
So if this application is to be heard, it has to be heard along with your
Along with my
that
with my exception, because
that earlier GA.
Absolutely.
As well as the consideration of the last report.
Last report,
Yes.
both. Now kindly see the prayer. Only the first report to be taken on record. How? You have to take on record both the reports.
That means that cannot be accepted.
Correct.
Court has the power to take that other report also into consideration.
Absolutely. But there has to be prayer, and only a decree can be passed after accepting the report. That is order 26 rule 40.
Question court, when there is a direction of the court, then report ought to have been filed, and the court is well within the power. Whether
There is no doubt. There is no doubt. Court has the
that
power.
the power has to be exercised.
Absolutely, court has the power. But the other exception with regard to the first report, that has to be considered.
Yes. Along with this report.
Yes, but that's the order.
That's it. I have already
Let appear all applications appear.
I have already annexed the exception. GA number 2033 of 2018. Kindly come to that page 13 of that exception.
I hope Lordship has got my point. This is what.
Yes, Lordship will also get my point.
নিশ্চয়ই স্যার রেগে যাবেন না?
So why are you doing so?
Page 13.
This is not a proper submission.
Yes, page 13.
13 clause 12. This is the exception in respect of the 10%.
Page 13 or page 12.
Page 13 of the exception report.
Yes.
And clause 12.
Clause 12.
Yes, Lordship. I'm just reading.
Oh, that is in your opposition.
It is in the exception application, GA number. That should be disposed of. That has not been disposed of.
12.
That is exactly what I am saying. That
Page
is exactly
12.
what I am
Okay, you have said.
That is clause 12.
Yes, Lordship, it is with me.
They have annexed in their reply. My learned senior friend has annexed it. I have taken 6 or 7 exceptions. So this has to be considered.
Lordship, I agree fully. But what is that thing? 12.
Yes.
I most respectfully state and submit in regard that if this honorable court direct the commissioner of partition to effect partition in respect of the third floor of this
Page 19. Page.
Running page possibly.
Lordship is looking at the reply.
Opposition.
No, they have annexed in their reply, my exception. They did not do it in their application. When I
it is a running page.
In their reply, they have annexed.
In reply.
Annexure D starts at page 10. I am helping my learned friend.
Running page.
Yes, page 11.
Yes.
11.
And prayer is page 19. I have taken master summons, my lord.
No, 13. Page
Paragraph
13.
19. Prayer to dekhi di, sir. I have taken out a master summons. Kindly see my prayer.
You have submitted. Let me submit.
Acha, sir. And my exception, Lordship would find in respect of all the floors, which was rejected, my exception to the third floor only.
That's it. Kindly come. Running page 20 in my reply. Evidently in reply. And page 13. Inner page 13.
Yes.
Clause 12.
Inner page 13.
Exception application.
Yes, clause 12.
First exception was in respect of the third floor. That has been disturbed of. And we have no objection. They have no objection. We have got position. It is okay. We are satisfied. But while doing so, what he has stated, let me say, I most respectfully state and submit in regard that if this honorable court direct the commission of partition to effect partition in respect of the third floor of the said dwelling house by allocating the plenty space to 1 bedroom, kitchen room and 1 toilet on third floor and permit the dependent to use the remaining portion of the third floor, the effecting partition, by effecting partition, then the dependent's problem of accommodation would not somewhat be resolved. I also respectfully state that submit that the using of the excess area, that is 10% of the third floor, excess area by the dependent, whatever it would, after making such partition of allocation, can be adjusted by giving excess area to the plaintiff.
May I say?
Let me see. Excess area to the plaintiff on the ground floor.
Paragraph 12 was confined to third floor. Paragraph 12.
At third floor, but while
that is resolved, there is no scope to go further to that.
Lord said, in the Justice Mukherjee's judgment, this has been taken into account.
Yes.
And
so whatever is resolved, that cannot be reopened.
This is not resolved. This is not resolved.
No, so far
there is a
floor is
dropping of
concerned.
Estopel, there is here. He is admitting what is kindly seen. Plaintiff, an excess area to the plaintiff on the ground floor out of my possession. He is stating therein, on the basis of this, Justice Mukherjee's order on the third floor has passed, that he will be getting that 10%.
So, just
and second floor.
order is confined to third floor, that is resolved. Apart from that, entire thing, entire inspection is done.
Otherwise, while disposing the third floor, he has taken this admission that I have no, so far the partition of the first floor and second floor concerned, I have no objection. Here it is also the partition of the first floor and second floor. And to what has been done by the partition commissioner.
So anyway, so let his application be taken up in this application. In this application, this amendment is there. Let this application be taken up.
Yes, Lordship. Lordship. Now, so the report on the basis Justice Mukherjee stated 17 December, you go through it. It is first floor wholly given, first floor given to the plaintiff, second floor given to the dependent, and 10%, 50% of the ground floor given to the plaintiff and dependent equally, and 10 only the dispute is regards to the 10%,
So
which is
yes,
admitted.
It is the position.
It is the position. 10%, Lord Visi, kindly.
No, given means what? Report or handed over position? Only the report.
My client has released that 10% on the basis of this commitment in the Justice Mukherjee's.
Is it mentioned in your application, in the present application?
Yes, kindly go through the Justice Mukherjee.
Paragraph. No, in your paragraph, have you mentioned that?
No, I'm not mentioning it. No, in the petition, I'm not taking it. But, or see.
So it's better let the application of Mr. Dev and your application as well as the latest commissioner's report be taken up.
Yes, my
Thereafter you file your written notes of argument.
my submission is this. So
And
this
one
is
more
a doctrine of records, and on the basis of which my client has forgotten.
So it is better, I think, let these applications be taken up, both the applications, along with the latest report submitted by the commissioner, and you file your, both of you file your written notes of
Your
argument.
Lordship would also direct, my lord, at least me, if not my learned friend, to file the entire report with annexures, because all documents are to be considered. When Lordship will be deciding the fate of the exception, Lordship would find what I have annexed, only the 2 reports. But the report contains certain documents.
So give it with your written notes of argument.
But in the supplementary affidavit, I would do that. In the supplementary affidavit, all annexures, because Lordship would be deciding my exception also.
Yes, that application, that is GA?
That is, my lord, that is GA 1993.
In my reply, I have already
Present number, that was the old number.
Present number, my lord, I do not.
You don't know?
I don't know, my lord, present number.
Acha, record.
আমি জানি না, sir, এটা.
One thing, sir, one service.
Let both the applications appear, Lordship would
In my
decide it.
affidavit
And
in
all
reply,
documents.
I have affidavit in reply. All other reports I will submit during hearing. So I am submitting hearing.
Record.
So kindly take it on record.
Learned advocate for the plaintiff and learned advocate for defendant number?
Well, only defendant.
Okay, learned
Sole
advocate
defendant.
for the defendant are present, are learned advocates. Upon hearing the submissions of the learned advocates, it appears that as GA, what is the GA?
Well, my
1933 of 2018.
1933 of 2018 is still pending for disposal. Let the said application, said the GA application.
I think they have filed their affidavit also. Let all appear, because everything has to be
GA
considered.
application along with the affidavits be put up on the next date fixed. Learned advocates are also requested to file the entire commissioner's report
with annexures.
Entire commissioner report with
That
annexures.
means the last report.
Both
Yes,
the reports,
commissioner's
There
last
are
report.
so many reports.
No, commissioner's last report.
Last report and the one which I took exception, that has to be considered.
No, that is there in the.
Yes.
Only the report, not the annexure.
Now, it is there with their application.
Sir, no.
It is there with
If
their
that is there, if that is there, I don't have to.
Are requested to submit.
It is
last report furnished by the learned advocate commissioner along with the annexures as well as the earlier report.
Earlier report dated 17th April 2017. 7th April 2017.
As well as the report dated
7th April 2017, which is on record.
April 2017.
It is on record.
Along with their written notes of arguments.
Okay. It is on the record. Everything is on the record.
Let the entire comprehensive application, let the
Yes,
thing be done in a
for
comprehensive
the
manner.
comprehensive purpose, it is okay.
Entire all the applications report and with your written
All the means report dated 7th April 2017. Report
7th April
2017.
আচ্ছা লাস্টটা কি বললাম 7th April 2017 হ্যাঁ ঠিক আছে
And the last report of
একবার দেখে নাও তো এটা
17th
that
December.
I've directed.
And the exception application.
Yes, exception is this GA.
And
This GA.
today is the hearing for the exception.
So your application and Mr. Dev's application will be taken up together along
Yes.
with the report and the written notes of arguments.
Exactly.
Okay, let this matter appear. Yes, when can you come ready?
Lord, give us some time because I have to prepare the note also and see the physical condition of my client. Lord, I need some time.
Okay, 25/6.
25/6. Okay.
25th of June.
June.
Lord, may it be in the first week of
Lordship,
July.
my
First week
client,
of July,
my
any
client
convenient
is
date,
suffering from cancer. He has gone heart operation. 2010
Any
it has
day
been
in the
filed.
first week of
And
July.
he is taking plea to prolong the cases.
1/7/2025.
Lordship.
1/7.
Poila July.
1st July.
Okay. Lordship.
Grateful.
Number 33.
Grateful.
My lord, item number 33, I'm appearing for the defendants number 1 and 2 in this matter. My lord, this matter is connected with another matter which was directed to be listed along with this matter. But my lord, despite 2 directions by my lord, the other matter is not coming up, appearing in the list, my lord.
Earlier, when was order passed?
My lord, 5th of May 2025, my lord had passed an order in this suit, which is CS 41 of 2011, that the other applications and suit CS 143 of 2013 should be listed together. My lord, the issue is in the both the suits relate to the same property. So, my lord, and the GA4 in both the suits are an application filed by an app.
No,
I am for the defendant in this suit.
yes, for the defendant. In this
For the
particular,
defendant number 1 and 2.
this suit
In
here,
this particular suit, defendant number 1 and 2. In the other suit, my lord, I am the plaintiff. And my lord, the plaintiffs are not appearing in this suit. It is only one applicant who has come in and filed an application for intervention, claiming to be the legal heir of one of the parties, but that particular person
is not present today.
He is present, my lord. Mr. Mojumdar is there. My lord, the issue here is it is a contested application because, my lord, we are disputing the marriage between the applicant and the person who the deceased plaintiff. And in that light, my lord, both GA4 in CS 140, CS 41 of 2011 and GA4 in CS 143 of 2013, identical applications can be heard out together.
Record.
And my lord, I'm praying for some time be given because this is for
Intervener and learned advocate for the defendant in CS 41 of 2011 are present. None appears for the plaintiff. In terms of order dated 5th May 2025, there was a direction that GA4 of 2020 in CS 143 of 2013 should appear along with this case, but the same is not listed. Stop. Thus, this matter stands adjourned till
my lord grants me a longer date. My lord, I am in some difficulty because the client cannot be communicated. I've tried in the meantime.
25th.
My lord, slightly longer date. Keeps it in the second week of July, my lord.
Okay, on 7/7/2025. Let the plaintiff be intimated. The department to submit copies, the records of CS 143 of 2013 on the next date fixed without fail.
Much obliged, my lord.
Another application is appearing.
34. This is same. Okay, same order. Okay, not today. Not today. Same, not today. 39, yes. 39, देखिए record टा देखिए last order की पास है. अच्छा, record. Order. None appears for the parties. Although today is fixed as a last chance, in terms of order dated 13th May 2025. Stop. Let an administrative notice be issued upon the parties and their learned advocates. Fix 23/7/2025 for report.
Milord, I beg to appear for the plaintiff. I have instructions to appear for the plaintiff.
So why were you not appearing on the last of so
The
many
problem
days?
is this is a change brief. I have recently got instruction. But I'm told, Milord, the previous advocate has not expired. Lord, so I will be requiring steps to be taken for filing.
Anyway, you see, this is the 1995 suit. It has to be disposed of expeditiously.
Absolutely, absolutely. Lord,
Anyway.
my suit for eviction. My suit for eviction of a
Several dead
trespasser.
parties did not appear.
Absolutely. Because of the demise, I am told, Milord, the problem had happened. So, Milord, I require to file, Milord, a wakalatnama also. And, Milord, the array of, Milord, the parties required to be changed because now only one plaintiff will suffice because she has, Milord, obtained
Anyway,
probate.
take necessary steps.
Milord, may I only inspect the file, Milord, of your Lordship, Milord, once? Kindly grants me that leave along with the leave to file wakalatnama also.
Learned advocate for the plaintiff is present and prays for leave to file the wakalatnama. It is submitted by the learned advocate that the former advocate of the plaintiff died. The steps could not be taken in the meantime. Stop. So, liberty is granted to file the wakalatnama and inspect the records. Let this matter appear on when
2 weeks hence, Milord, I will also come up with an application also, Milord, that will, Milord,
let
ease
this
out the
matter appear on 25/6/2025 under the same heading. Let necessary steps be taken in the meantime.
I'm grateful. Not only one thing, Lord, may I have a look into the records?
Yes.
May I have a look into the records?
Yes,
Lord?
yes, I've given. Inspection may be done.
Great.
41, देखी last order. Okay. Very good. None appears for the parties, although today is fixed as a last chance. Stop. Let an administrative notice be issued upon the parties and their learned advocates. Let this matter appear on 23/7/2025 for report.
Item number 42.
42 রেকর্ডটা দেখি। এই অর্ডারটা ওই একই অর্ডার করে দেবেন।
Number 43.
43 আগের অর্ডারটা দেখেন। ও None appears for the parties. when the matter is called. Let this matter appear on 25, 26, 6, 2025 as the last chance. তো কোনটা? কত নম্বর আইটেম এটা? ও আচ্ছা আচ্ছা। এক মিনিট, এক মিনিট। ফর্টি-থ্রি অর্ডারটা তাহলে কেটে দিন। Report is submitted by the register original site. It is stated in the said report that GA1 of 1995 was disposed on 16/11/1995. Stop. The wakalatnama and written statement were filed by R. Khaitan advocates on behalf of the defendant. As the suit is of 1995, let administrative notice be issued upon the parties and their learned advocates on top, and let this matter appear on 24/7 করে দিন, 24/7/2025 for report. এই সব ডিপার্টমেন্ট থেকে অ্যাডমিনিস্ট্রেটিভ যায় না, সব ডিপার্টমেন্ট থেকে যাবে। না না না, সিম্পলি ডিপার্টমেন্ট থেকে যেরকম অ্যাডমিনিস্ট্রেটিভ নোটিশ যায় সেভাবেই যাবে পার্টিদের উপর, পার্টি অ্যান্ড দেয়ার অ্যাডভোকেটস।
Item number 44, Your Lordship, I'm appearing for the defendant. Matter is appearing after so long. We have tried contacting our client, and very recently we have been informed that our client is suffering for liver cirrhosis, and therefore he could not provide us any instructions. So I'm
Anyway, I am granting you 4 weeks time.
kindly make it 6 weeks, Your Lordship.
Learned advocate for the defendant is present, none appears for the plaintiff. On the prayer of the learned advocate for the defendant to take necessary instructions, the matter stands adjourned till 9/7.
Yes, Your Lordship.
9/7/2025.
Obliged, Your Lordship.
Learned advocate for the defendant is requested to intimate, take necessary instruction, as well as intimate the learned advocate for the plaintiff in this matter about the next date fixed. So intimate the learned advocate for the plaintiff also. দেখি কি অর্ডার আছে। 45 অর্ডারটা লিখে নিন। None appears for the parties when the matter is called. Although today is fixed as the last chance, let administrative notice be issued. Stop. Let 24/7/2025 be fixed for, let administrative notice be issued upon the parties and the learned advocates. Let this matter appear on 24/7/2025 for report. Forty-six হয়ে গেল তো না 46 হয়ে গেল তো এ 46 এ Yes, record and order. Report submitted by Registrar Original Site in terms of order dated 20th March 2025 be kept with the record. None of the parties have appeared. Stop. The case stands adjourned till 24/7/2025. Let administrative notice be issued upon the parties and their learned advocates.
Item number 47.
It is same order. Yes.
May I, my lord, I believe,
Yes.
my lord, your lordship has a division bench in the second half.
At 3 p.m.
Now the court will continue.
No, 2 p.m. this court will sit. 3 p.m. there is a division
I'll
bench. 2 p.m. fixed matter আছে
Well, may I have, my lord, one indulgence, my lord? My lord, item number 54, my lord, of your lordship's, my lord, today's list. I know that.
54, yes.
My learned friend, for the plaintiff is also there. In any event, my lord, I would have sought adjournment, my lord. May they appear, my lord, sometime next week, Monday? Thursday after, I mean, day after issue adjournment চাইবো সেজন্য বলছি Monday, let it be on Monday. If it
Okay,
gets-
item number 54 লিখে নিন on the prayer of your father.
I am for the defendant, my lord.
On prayer of learned advocate for the defendant, item number 54.
54, my lord.
The matter stands adjourned till
Which?
17/6.
My lord.
76.
On that day. My lord, we'll come back. We'll come back.
17/6/2025.
We'll come back, my lord.
Well, at an item
Deeply
number
obliged, my lord.
66, your lordship.
Yes.
The last item, my lord, 66, your lordship.
66,
Yes, my lord. Today was the date fixed for witness action, my lord. My lord, what has happened, your lordship? The witness is due to some medical emergency out of Calcutta, out of
No,
station.
it will not be taken up today because 2 p.m. there is a fixed matter. It will not be taken up.
My lord, I'm humbly beseeching your lordship to keep it anytime next week, your lordship. That's why.
Okay, item number 66, not this week, করে দিন.
Your Lordship, item number 55, I'm appearing on behalf of all the plaintiffs. We are praying for an adjournment of 4 weeks. The plaintiff number 1B has died. So we will file the substitution application this week. Kindly allow an adjournment of 4 weeks.
Achha, item number
55, Your Lordship.
55. You are for?
I'm for all the plaintiffs.
Okay, item number 55 on the prayer of learned advocate for the plaintiff. The matter stands adjourned till 2/7/2025, 2nd July.
Grateful, Your
Lord,
My lord, can it be on next
July.
Thursday? No, my lord. The previous item, the last at 66, your lordship. Can it be on next Thursday or Friday?
I've made it not this week probably.
Yes, your lordship. Because on Monday it will again appear, so I have to seek an adjournment in any event.
So come on Monday, I shall see.
My lord, item
Seven, my lord. I'm appearing for some of the defendants, my lord. Here, my lord, I'm led by Ms. Ranjabhuti Sen. She is not available, my lord. So I was humbly praying if it could be taken up as an adjourned for another month, my lord.
Item number 57 on the prayer of learned advocate for, you're for learned advocate for?
Defend numbers 2 to 7, defend numbers 21 and 22. It's a partition suit, my lord.
Number 2 to 7 and
21 and 22.
And 21 and 22. The matter stands adjourned till 8th of July, 8/7/2025.
Very well, my lord. Grateful, my lord.
Lord, item number 64. I am for the plaintiff in this matter.
Item?
My lord, item number 64. Item 64. 64. Well, I
Taken
am
up.
for the plaintiff in this matter.
Yes.
Malab, here the mean profit commissioner is to submit his report, my lord. I'm told that Malab, only 2 weeks are required to submit the mean profit report, my lord. May that be extended for a fortnight, my lord, for submission of mean profit report, my lord.
64
Commissioner's report.
On the prayer of learned advocates, the matter stands adjourned till 26/7/2025.
26/7. I'm grateful, lordship. I'm for the plaintiff.
Lordship, item number 63, kindly grant 2 weeks time.
Item number 63.
In item number 63, I appear for the defendant. This is the third time that they're taking an adjournment for 5 days.
একই অর্ডার করে দেবেন তো এই যে হ্যাঁ give your appearance.
The Lordship?
Yes, yes.
Virtually appear করেছে তো একটাতে. Give your appearance.
Okay, I'm doing that. I'm doing that, my lord.
Item 55.
63.
Item 60.
63.
Item 63 on the prayer of learned advocates. The matter stands adjourned for a period of 2 weeks. Let this matter appear on 24/6/2025.
But I'm objecting, Your Lordship. This is the third time that they're taking an adjournment for filing an application for adducing evidence through commission, Your Lordship. File that application, Your Lordship will continue with this.
Okay, come on the next day. I shall come on the next day. I shall see.
লিখে দেবেন নাকি? লিখে দিচ্ছি। আপনি লিখে দিয়েছেন? লিখে দিচ্ছি। Item 64. 64
Matters fixed at 2 p.m. All suits item number 38.
For the defendant.
I had briefly made my submissions yesterday. I'll just summarize the point. Effective 9th. But firstly, my submission is that if your lordship looks at the order of the division bench and the order of the Supreme Court,
Yes.
the order of the division bench plot is at page 102. Which
Yes.
plot disposed of GA8. GA8 plot originally was dismissed by the learned trial. I've placed that order before your lordship. It was an application under Order 7, Rule 11.
Yes.
The learned trial judge held that plot application under Order 7, Rule 11 was not maintained.
Yes.
Now, against that, the matter came to the division bench. The defendant plot preferred an appeal to the division bench. Division bench held that whether the suit had become spent force or the suit is not maintainable, that can't be decided in Order 7. So the division bench directed that this issue be treated as a preliminary issue. If your lordship,
That maintainability.
maintainability be treated as a preliminary issue under Order 14. My lord, kindly take page 102 of the application.
Yes.
This is the order of the division.
Yes.
Lord, if your lordships kindly come to page 104. Just above, Lord, the quotation of Order 14, Rule 2.
Yes.
My lord will find it says, just 3 lines above that. It says, it is true, has your lordship got that? That whether the suit had become a spent force or not would not be decided in an application under Order 7, Rule 11 or under Section 151 of the Civil Procedure Code. Then Order 14 is quoted. Kindly, Lord, turn the page. If the suit has become academic after the quotation and infractuous, it goes to the jurisdiction of the court. The court would no longer retain jurisdiction to adjudicate it. Once it is a jurisdictional issue, it can be tried as a preliminary issue before all other issues. This preliminary issue may not be only an issue of law, but an issue of fact and law rolled into one. We are of the view that the questions raised in the application before the court below in GA 2023 should be tried as a preliminary issue in the suit on the basis of the application and the affidavit exchanged thereto before the suit proceeds any further. The learned single judge may direct documents to be disclosed relating to that issue only, invite evidence to be adduced in court or by commission, whichever the court deems fit and proper, and decide the question as soon as possible. Depending on the decision of the court on that issue, suitable directions may be made, either disposing of the suit or directing the suit be tried and determined on all issues arising therein. At this stage, Mr. Mukherjee submits that there is a pending application GA6 before the learned single judge. We say that it should be open to the learned single judge to decide in what order the preliminary issue or the pending application is to be entertained by the court. We request the learned trial judge to decide on the preliminary issue within 3 months from the issue. Now, my lord, two things arise out of this order. One, that the issue should be tried as a preliminary issue, and my lord, GA6, the trial judge is at liberty to consider GA6. Now, when the matter travels to the Supreme Court, page 109, paragraph 2, the Supreme Court says we are not inclined to interfere with the impugned judgment and order. Then 3, nonetheless, we clarify that the trial court single bench shall be at liberty to proceed with the suit itself in accordance with law, having regard to the developments which have taken place pending proceedings. So, my lord, the discretion is not now only to decide the preliminary issue. Your lordship can decide the whole suit. Then it says both the parties shall also be at liberty to file appropriate proceedings before the trial court single bench as may be permissible under the law, and if such proceedings are filed, the same be considered without being influenced by the observations made in the impugned order passed by the division. We further clarify that we have not expressed any opinion on the merits of the case. But in fact, before the Supreme Court, we have the Shebites had filed an application for release of the fund.
This is before this court.
No, here GA6 was filed.
Yes.
The division bench directed GA6 to be disposed of by the trial judge. But when the SLP
So
was...
this is GA9.
This is GA9.
Yes.
This GA9 has been filed subsequently. The Supreme Court also, the Shebite not asked for release of the fund.
Where is that application?
That application in the affidavit in opposition, it is annexed. It is mentioned in the petition. So the page 88. 80? 88. Page 88. And the prayer is brought at page 93.
Page 88. Okay, this was the application by the Shebites.
By the Shebites.
Shebites plaintiffs. In which SLP? In this?
In the present SLP that the Shebites filed, the Shebites also filed an I, the interim application. Because for the Shebite, it is becoming impossible to run their administration. This is the only property that they own. And the DT is in a very distressed situation. From December 2019, nothing is received. So, page 88, the prayer, application starts. The prayers are at page 93. So this liberty was preserved.
Page 92.
93.
93.
Can you see the prayer? Orders be passed directing defendant respondent Plessy to make payment of a sum of...
No, this is an interlocutory application filed before the Honorable Apex Court along with the SLP.
Along with the SLP.
So, when SLP is disposed, entire applications are all disposed.
All disposed of.
But but not on merits.
Not on merits. Giving liberty to file an application, appropriate application before the...
Is there any observation that the Shebites have filed this application?
Kindly come to...
Page 105. 110.
109.
109. No separate order passed on this application. Disposed along with this.
Yes.
Okay. So, no, any observation that this this application is also disposed. Okay, IA is there.
Yes. IA.
Oh, appropriate orders. So you being the respondents, no, you are the petitioners.
I being the petitioner, I filed the SLP challenging the order of the division bench I also filed an application seeking payment.
So that is there, the only that number is there.
Yes. Good, your lordship will.
Yes. সাড়ে তিনটের সময় তো ওই জায়গায় মোটামুটি 3:30 পরে উঠবো আর কি।
how these obligations are to be discharged. The court will not fix the time limit. Suit was adjourned for a period of 5 years. They had to demolish the property, they had to build. And the court put an obligation on them to pay an enhanced amount of rent. And this enhanced amount was to go up further periodically by 12%. Go up. Now, Lord, if your lordships kindly have a look at the chart which is annexed to this petition at page 115. Kindly take the petition and come to page 115. Payment is due from December 2019.
Page 105 of your petition.
115 of the
Oh.
petition. Petition, not the opposition. $5,28,000
Yes.
was the rent payable in 2019. And Lord, this has gone up to 5,92,000 from April 2023. Kindly, Lord, turn the page. This 12% increase is factored in here. Kindly turn to page 116, serial number 41. From April 2023, they are to pay 5,92,076. Has the lordship found that? So, Lord, 5,92,076 is now the rent which is payable. This has been calculated up to February 2025 till the application was filed. Now, not another 3 months is added.
Now, now also 5,92,000.
92,000 because Lord, from April 2023, 5 years, they will enjoy this rate.
So that GS6 was up to 2022.
22.
And this is up to 2025.
So, Lord, may I just briefly, Lord, point out? So, Lord, this is an application for securing, Lord, the occupation charges, which is payable by the tenant during the pendency of the suit.
You see two things. Securing, this is not securing mean profits.
No.
It is securing.
Rent.
Securing means you are
Payment.
claiming the rent.
Yes,
Not question of securing any mean profit.
I am seeking payment of the agreed occupation charges, and this I am saying that this should come to.
So it is on the basis of this terms of settlement and the court's order.
Court's order.
So not a question of securing any mean profit.
In the alternative, I have made that trade. In the alternative, I have made that trade.
Oh, if it is a question of mean profit, then a
It is
question of securing
This is not
comes.
This is not a mean profit. This is not directly quantified by the court. Amount quantified by the court.
Because mean profit has to be
Quantification
quantified.
That is the reason why in this order, judgment of the Supreme Court, they were asked to deposit the rent. The distinguishing feature here is that here the court has fixed the amount. Irrespective of the result of the suit, I am entitled to receive this rent.
Yes, that is why you see mean profits are to be deposited in court.
Correct.
But so for occupational charge, either deposit or pay directly to the landlord.
Absolutely.
But
And I have a liberty to withdraw that money. Even if the court directs deposit of rent, I have always liberty to withdraw the money because the court gives me that liberty. That is the normal course of action. Because, Lord, even under the Transfer of Property Act, if your lordship looks at section 108, the obligation of a lessee is if he is occupying to pay the rent. 108, if your lordship kindly takes section 108, Amit. 108 Lord has two parts. First part says that rights and liabilities of the lessor, and the second part says rights and liabilities of the lessee. Kindly take.
আছে ট্রান্সফার অফ প্রপার্টি নেই, এখানে নেই।
On the rights and liabilities of the
That means
lessee.
right to receive the lease rent.
Yes. Your lordships will kindly see L.
Yes.
Kindly see the rights and liabilities under rights and liabilities of the lessee. Lordships kindly see L.
Yes, lessee is bound to pay.
So, Lord, this is an obligation,
Contractual or statutory, as you may say.
both contractual as well as statutory, because this is protected by a statute. And therefore, Lord, there is no escape to the fact that
That during pendency of the suit.
it has to be. Because if they are occupying the property, they have. Merely saying, I am not in occupation, Akriti is, that is your creation. It's a matter between you and Akriti. What you do, you settle it, but your obligation comes from the supplementary deed of lease, where you have unequivocally admitted your liability. And also, this is covered by an order, interim order passed by the court.
Yes.
So, my lord, two things. There is no dispute as to quantification of the amount payable by the lessee. This is already adjudicated, determined by the court at the interlocutory stage. The second is the court has absolute power.
Yes.
The court has absolute power to protect the interest of the parties during the pendency of the suit. And this direction that I am seeking is in the interest of protection of the interest of the plaintiff. This is notwithstanding the proceedings and the orders.
Yes.
Which directs your lordship to decide the issue either as a preliminary issue or as a
Along with other issues.
along with the other issues in the suit. That is your lordship's discretion. But that does not make the court powerless to pass this order protecting the interest of the. Look, these are my submissions in support of my application. Look, so far as the reply is concerned, if your lordship Lord kindly gives me a chance to give the reply, not tomorrow, but or tomorrow.
Anyway, that you can suggest a date.
Tomorrow itself. Tomorrow itself after Mr.
Yes, Mr. Dotto, you want to submit? Let your junior submit. He was hearing all the time. But you just now came. So he was hearing the submissions.
He is very
So let him start. Thereafter you take up.
But I have a backup fix at 3 o'clock. That's why I'm sitting.
No, I have also to rise at 3:30 because there is a division bench.
Kindly request tomorrow or any other day, whichever date is convenient, for giving a reply.
You want to give a reply, no? Anyway, if you want tomorrow, I can keep it at tomorrow at 2 p.m. Oh, 2 p.m. fixed আছে 3 p.m. কিছু আছে fixed 3 p.m. আছে fixed আর সোমবারে 2 p.m. আছে কিছু fixed সোমবারে 2 p.m. কি 3 p.m. না সোমবারে না নেক্সট সোমবার কামিং সোমবার
16
কামিং সোমবারে 2 p.m. কি 3 p.m. এ দেখুন কি সোমবারে কামিং মঙ্গলবার
Coming Mangalwar? 2 p.m. Yes, next Tuesday at 2 p.m. What do you reply? Yes, Mr. Datta, if you want, you can, or you can, your junior can start. No, because he was here, he was hearing.
Getting this opportunity to address the court and the court wants.
Because you just now came and he had the opportunity to hear the submissions. Anyway, you start thereafter, Mr. Datta will take up.
Now, your Lordship, my lord, has been informed regarding the skeleton of the matter. But our contention, my lord, at this stage, because your Lordship has seen that this is a very old suit. At this stage, my lord, our contention with GA8, and that is the general application based on which the matter went up before the Supreme Court, through the Honorable Division Bench, again came back before this Honorable Court, and orders have actually already been passed, in which order your Lordship is going to hear the suit. My lord, we accept that the Honorable Supreme Court has given certain limited liberties to the parties. But the sequence, my lord, has already been decided by this Honorable Court. My lord, our contention is that this, my lord, originally is a suit based on forfeiture of a lease. It is not a 106 action of monthly tenancy, because there admittedly, as on date, is a continuing lease deed, which is existing between the parties. Now, my lord, in 1985, a notice of eviction, my lord, was issued based on certain breaches. And those breaches, my lord, are very, very important. And his Lordship has been shown, and we will also rely on those grounds. Only two grounds. The first ground, my lord, was default in payment of rent for the period which was contemporaneous to 1985. And it ended immediately before the suit was filed in that period. So it was an action which took place, default took place naturally before the suit was filed. That was first point. First ground for forfeiture. The second ground was complaining non-completion of the building. So these were the only grounds, because it has been told to your Lordship that there were other breaches. I'm sorry to say there was no other breach other than these two, and these two alone. So the question which now comes for consideration, apropos jurisdiction, before your Lordship is whether these two causes survive as on date or not. A. B. Does the supplementary deed of lease, which is the last recorded document between the parties, because prior to that there was directions passed by this Honorable Court, one by Justice Pinaki Chandra Ghosh, as his Lordship then was, and other by Justice Patheria, as his Lordship then was. And after that, there was a supplemental deed of agreement which the parties had entered. So that is the last recorded terms between the parties. And that specifically has a covenant which records the lessor's obligations. What is the plaintiff? Because plaintiff is the lessor. And the lessor's obligation involves that if the construction has been made, now, my lord, they are asking for rent. Of course, the construction has been made. Of course, people are residing there or using it for gain. And that is the reason why we had been paying rent to them. So naturally, construction has been made, and it is so. So if construction has been made within a period of 5 years, from the date of passing, from August 2010, because that is the date, 3rd August 2010 is the date for
construction is made but not completed.
No, construction has been made and it has been completed.
And okay.
There is, my lord, if I may say, a very feeble allegation made that there is no completion certificate. In a humorous manner, my lord, 99% of the buildings here in Kolkata do not have completion certificates. But that is not the point, my lord.
Construction has been made, and construction was to be made. That was the covenant. Construction has been made. There was the other covenant in the supplemental deed, that is, if there is no breach within the continuous period of 5 years from August 2010, then the suit ought to have been struck off. That is the term used, which obviously means that the suit should have been dismissed. The plaintiff should have approached the court saying that there has not been any breach, 5 years period is over, so this suit does not have any surviving cause anymore. This was not informed in 2015 because 2015 was the 5 years from 2010.
Yes, you may take up.
Third, I'm led by Mr.
As my learned friend Junior has indicated, that so far as this suit is concerned, this suit hinges on
Yes.
This suit hinges on a notice. Your Lordship knows, my Lord, in suits for eviction, either under the Tenancy Act or under the Transfer of Property Act, if it is 111 notice, then the lessor is complaining of breach of the covenants. He has to give me a time to remedy the breach, failing which I am liable to be evicted under 111. So, and in the Premises Tenancy Act, of course, my Lord, the grounds have to be established in trial strictly in terms of the notice.
No, premises tenancy, definitely. Unless there is a notice, then there's
So
no
the
cause of action.
so apart from expiry of lease by efflux of time, in all other cases of breach, my Lord, under section 111, and I shall, if necessary, show that the plaintiff has to prove and establish the breach to get a decree.
Yes.
Now, it may so happen, and which has happened in this case, is that at the time of trial, I can show to the court that the cause of action in the plaint does not survive anymore. If the cause of action in the plaint does not survive anymore, then in that event, no interlocutory orders can be passed in that suit.
Yes.
And if my learned friends are alleging that there has been a subsequent breach, if they are alleging that there is a subsequent breach during the pendency of the suit that necessitates a notice under 111 again, the notice of eviction cannot be amended to bring in additional grounds if at all there exist. Now, my endeavor would be to show to your Lordship, my Lord, the first impression of the court, because today my learned friends are coming and asking before your Lordship that this is a person who is in occupation of a premises not paying rent. So compel him to pay rent.
So you have to justify your occupation, your presence without paying rent. That
No.
also you have to justify.
All I have to justify before your Lordship, my Lord, subject to correction, is that I can be evicted if I'm a defaulter. But I don't know of any law which compels a tenant who doesn't want to pay rent or is not liable to pay rent, that the court will compel him to pay rent, because that would be a breach. So that is why there is a ground of defaulter both under the TP Act as well as that you are not paying rent and you are a defaulter. Today, my learned friend's case is simplicity a case of defaulter. And that defaulter, kindly now, my lord, take page 18 of my opposition. Default has to be part of the plaint.
Okay, page 18.
Page 18 of our opposition. Prior to that, Miller, before going to page 18, kindly come to page 35.
Page 35.
35.
Yes.
Miller, your lordship will find it's a notice under 111G, expressly written there 111G of the Transfer of Property Act. On the basis of this notice, this suit has been filed. What are the two grounds? Kindly, my lord, see. We are instructed by our client such and such, such and such, such and such to estate to write to you as follows. Please take notice that the indenture of lease dated 4th February 83 made between our above clients as lessors on the first part and lessees of the second part, as confirming party of the third part, contains inter alia the following terms. To pay to the lessors 26,000 only per month from 1st April 85 to September 1991. Kindly, my lord, mark the date. To the lessee, to the aforesaid monthly rent in all cases regularly within the 10th of every month following the month for which the same shall have become due and payable. So the default alleged in the notice is 1st April 1985 to September 1991. This is the period of default.
Yes.
The second is the lessee shall demolish the existing structure at its own cost at the value of the demolished structure will belong to the lessors. Before demolition of the structure, the lessee will give 1 week's notice by registered post with acknowledgement due and have to remove the demolished building such and such and receipt of intimation upon completion of such demolition from the lessee. And the event of the lessor's failure to do so, the lessee on 3 days prior notice to the lessor will be entitled to remove the building materials or sell the same and pay the amount you realized from the lessor after deducting all costs and charges. The lessee shall, after demolition, construct a new building on the demised premises at their own cost up to the optimum height permissible under the Kolkata Municipal Corporation Act within a period of 5 years from the commencement of the lease.
Yes.
The indenture of lease also provided that forfeiture of your interest as a lessee with consequential right of re-entry in the premises for violation of any of the above covenants. You have violated. This is the cause of action in the suit. You have violated the covenants by failure to pay the monthly rent dues payable by you at the rate of 26,000 per month from 1st April 85. And you have also failed to demolish the existing structure at your own cost with notice to our clients under clause 3 of your covenants in the said lease and construct a new building on the demised premises at your own cost within a period of 5 years from the date of commencement of the lease, that is 1st April 85. Under clause 4 of the covenants, you have been doing so even now, or if our clients have not condemned such breaches of your covenants under the same. You are served notice on the 15th April by registered post with acknowledgement for remedying the breach of your covenants, the said lease and the said notice you have duly received on 23rd. We do hereby give you notice of determination of the said lease, calling upon you to deliver a vacant and peaceful possession of the premises described to our clients upon expiry of the month of August, failing which our client shall exercise right of re-entry. This is the allegation in the notice. The plaint on which, my lord, your lordship is today asked to pass interim orders is at page 18.
Page
18 of the opposition, the same.
Yes.
Kindly, my lord, come straight to paragraph 22, page 22, paragraph 7.
Running page 22.
Yes, my lord. Yes. My lord, it refers to the notice of 11th of July 1988 and thereafter the subsequent notice. By notice in writing dated 19th April, addressed by the plaintiff to their advocate such and such, by registered port such and such, the particular breach complaint of regarding failure on the part of the defendant to construct the new building on the premises within 5 years from the date of commencement of the lease was duly specified in clause 4 of the lessee's covenant contained in the deed of lease. The defendant was duly called upon and required to remedy the breach within a period of 3 months from the date of receipt of notice, which is a reasonable time in the facts and circumstances of the case. The defendant, however, in spite of the did not use service thereof, as aforesaid, failed to remedy the breach within the stipulated period, reasonably period, or at all. In view of the context that has been stated herein above, particularly in the 3 next preceding paragraphs, the plaintiff by notice of July 2685, this is the notice which I just read, served upon the defendant by registered post and conveyed to the defendant their unequivocal intention to determine the lease and call upon the defendant to deliver a vacant and peaceful possession of the premises to the plaintiff with expiry in the month of August 85. The defendant failed and neglected to vacate the premises or deliver possession thereof to the plaintiffs as required by notice and copy of such. By 2 covering letters, this is important, my lord. By 2 covering letters of 19th August 85, the defendant forwarded the advocate on record for the plaintiff 2 several checks purporting to cover the contractual rent up to August 85, which is, my lord, my defense under 114. The plaintiffs, as advised, have not, however, accepted the same, lest it be contended on behalf of the original defendant that by acceptance of such rent prior to institution of the suit, the forfeiture incurred by the defendant stood waive. The check was thus returned. Then, my lord, kindly the last 3 lines. The plaintiff, however, is entitled to claim in the suit area of rent up to the date of forfeiture of lease, thereafter mean profits at the contractual rate of rent till the date of institution of the suit, and the same amounts to 14,98,000 such and such. Now, my lord, kindly come to the prayers. This is the scope of the suit today at page 25. So, my lord, eviction for breach for not starting construction and completing it within 5 years. From 85, non-payment of rent of 14,000 rupees till date of filing of the suit, mean profits. There is nothing more in the suit.
Yes, so this is what the plaintiff has claimed.
This is the suit which is now ready for, which is sought to be heard.
Yes.
Now, my lord, in this suit, I shall show subsequent. Now, in this suit, the subsequent facts that have come up are not before your lordship.
Yes.
Now, my lord, what happens is in this state, when the parties go, my lord, when my learned friend's client file an application for the first time in 2003, there is an order passed by consent. The rent that was there in the original lease was enhanced. The period for which I was to demolish and make construction was enhanced. Now, my lord, if I may ask myself this question, if that has been enhanced and the parties subsequently to the eviction notice agreed to enhance the time, what remains of the breach that is alleged in the notice?
That means what remains in the suit to be decided.
Right. So, my lord, subsequently, if the lessor has agreed to give me an extension of time for another 10 years to complete the construction, and he has received rent from me till 2020,
Yes.
my lord, this cause of action is dead and gone. Now, before I, because I believe my lordship is in a hurry, my lord, kindly permit me to place two orders. One is at my lord page 55. Justice Ghosh's order, my lord, my learned friends have placed, but has not
55 of your opposition.
in a petition. Of petition. 49 of petition.
Yes, page 49.
Yes, my learned friend had placed the portion to show that the time was extended for making construction, and the rate of rent was also enhanced. May I just hurriedly place this order, Miller? Miller, at page 49, in 49A, Miller, the typed copy is at 49A.
Yes.
Miller, in view of the discussion and the terms of negotiation between the parties, this is a negotiation that has been recorded by court post the suit for eviction. In respect of the two issues, which is the subject matter of the notice of eviction. So, Millard, can I not say with respect that the cause of action or the breach alleged in the plaint stood waived?
Yes.
Then, Millard, I passed the following order is passed. So the order is passed not at the instance of the court. The order is passed on the terms of the negotiations that the parties have laid down before the court. So this is a kind of an order where the court parties, both the lessor and the lessee, have invited the court to pass. There is no adjudication. It is directed that the applicant Andrew Yule, after demolition of the existing structure on the demised premises such and such, shall start the new construction on the demised premises within 2 years from the date of this order. So that breach that you have not constructed within 5 years from 1985, from the date, that breach is gone, because now a fresh time has been set. I am at page 49A.
Yes, 49A.
Yes. So, that period, as your lordship, that two years period is
yes,
there.
2 years from the date of this
Order, and shall complete the construction on the demised premises up to the optimum height permissible for the Kolkata of the new so new building according to the plan sanctioned by the Kolkata Municipal Corporation within the extended time of 5 years from the date of this order. So we have moved out of that breach, and the Xerox copy of the sanction plan duly attested will be handed over by the defendant plaintiff to the company to the plaintiff. Then Milord 50A. It is further directed that after demolition of the existing structure on the demised premises, the debris had to be removed by the lessee at their own cost. It is recorded that the value of the existing structure at such and such in the be determined by approved valuer, not very relevant. It is further directed dependent shall pay monthly occupation charges. Kindly similar, the rate of rent is being enhanced. Directed the defendant shall pay occupation charges of 1 lakh per English calendar month in place of the present occupational rate of 30,000 per month from April 2002 to 31st March 2008. Now, Milord, if I may ask myself this question, if this is the new rate of rent that I am to pay, that allegation in the plaint that I am a defaulter for 4 months from August to September 85, no more survives because the parties have agreed to an enhanced rent.
Yes.
It is further directed, this is important, Milord, kindly make mark of it. The further directed, the company shall pay the area occupation charges from the month of April 2002 to 31st March 2003 at the rate of 10,000, only less the amount already paid within 8 weeks from date. So whatever has been paid would be adjusted, the balance would be paid. Further directed that the company lessee will pay to the lesser monthly rate of 3 lakhs per English calendar month from 1st April, and there will be an increment of 10% of the monthly rent every 6 years until expiry of the lease. The extent of increment in occupation charges rent as ordered in clause 1 subclause 6 of the deed of lease shall stand modified accordingly. So the lease terms were modified and a fresh lease had come. Apart from payment of rents and taxes referred to in the deed of lease, the lease shall also pay all other tax. Lessee shall also pay all other taxes, including water tax, fees, such and such. Certificate of paid up rate of bills for the KMC confirming that there is no outstanding dues or tax shall be furnished. Shall also furnish regularly rate bills for KMC. Then it's very important, Milord. What if I breach these new terms? If I breach the new term, then the consequence is this. It is further directed that the defendant applicant fails to start construction on the demised premises within 2 years from the date of this order, other than 49 years, that is the initial period of lease, there shall be no option by the lessee for renewal for a further period of 19 years as contemplated in the original lease deed. And in this respect, the operative part of the lease deed containing the option clause stands modified. This is the consequence if I don't, not eviction. So the original breach in the plaint that I am liable to be evicted if I don't start construction within 5 years stood modified by the consent of the parties, which says that if I don't or fail, then in that event I am not liable to be evicted. That won't be considered as a breach. Only the right of having it renewed for another 19 years would be lost. So where does the cause of action in my respectful submission will it survive? It is further directed that the defendant applicant fails to comply with any part of the order he made, the defense of the defendant company shall be struck out and the suit which stands adjourned for 5 years from the date hereof will be transferred to the list of undefended suits for obtaining as ex parte order. If the defendant applicant, this is very important, Milord, If the defendant applicant complies with the aforesaid orders, it is deemed sufficient compliance with relevant clauses of the indenture of 4th February 1983. And in that event, the plaintiff on expiry of 5 years shall get the suit struck out.
Yes.
So, Milord, if I can show that I have constructed and that they have received enhanced rent, the suit is liable to be struck off.
Yes.
It is further directed that a supplementary lease deed incorporating therein the modifications as made in this order shall be executed and registered by the lessor and the lessee.
So that was done.
That was done.
So this paragraph.
So, Milord, today we have a supplemental lease which takes care of both the breaches which is complained of in the suit. And both the terms have been altered by consent of the parties. So those breaches do not survive.
You have paid rent till which year?
Till 2020.
Till 2020. And this is in 2003.
It's in 2003. Now, Milord, what happened is this. Kindly now see, this was the terms of the supplemental lease is at page 57. Page 57. Oh, sorry, Milord, kindly come to page 55 once.
Yes.
That was of 2003. By agreed terms, the parties further negotiated. By the agreed terms filed in court in GA 1778 of 2008. So 2003, 5 years was 2008. So in 2008, Milord, the parties further negotiated.
2008, this GA 1778 was for what?
Milord, it is, Milord, for amending the lease further. So the timeline was 2003, Justice Ghosh gave us 5 years and altered the entire lease.
Yes.
And thereafter, the parties again approached the court and filed fresh terms in 2008 after expiry of 5 years. And entered into a supplemental lease and a list of dates like because petition, opposition, হচ্ছে তো না জজ সাহেবের জন্য Well, kindly take the trouble of coming to page 57.
Yes, page 57.
This is the supplemental deed of lease of 5th August 2010, which is supplementing, Milord, the original lease. Now, Milord, why was this necessary is evident from the recital. Kindly, Milord, come to the recital portion where it starts from page 62. Yes. Page 62, Milord. Miller, last paragraph. And whereas for various reasons, neither the demolition of the existing structure nor the construction of the building could be carried out by the lessee within the extended period of 5 years, as mentioned in the order of 16th of April 1997, and the lessee again filed a petition inter alia praying for further extension of time for construction of the new building. Huh? 66, yeah?
So this DA 1534.
Miller, time to time various GAs were filed.
Yes, and terms were modified.
Terms were modified. They kept on modifying. Ultimately, Millard, if your lordship, Millard, to cut the matter short, if your lordship, Millard, comes to page 66, this is the final modification. And whereas, Millard, at page 66.
Page 66 is that is 2008.
Yes, Millard, it's the deed of lease. These are recitals to the deed of supplementary deed of lease. And whereas
Okay, page 66 is the final modification.
yes, last Millard, it takes care of everything. The facts are stated. I don't want to waste your lordship's time on that because that would be relevant, but for this application, I don't think I need to go through it. And whereas in the event aforesaid, it is necessary to enter into a supplemental deed of lease, which is this one, current document, modifying some of the terms and conditions of the principal deed of lease of 4th February 1983 in pursuance of the order of 21st May 2009. Such supplemental deed of lease is hereby executed and registered by and between the parties hereto in terms whereof. Now this indenture witnessed and is hereby agreed that the presents are supplemental to the principal deed of lease of 4th February 83 in pursuance of the directions under the order of 21st May 2009 and in the context aforesaid, clause 6 of subclause 6 of clause 1 and clause 3, 4 and 5 of the lesser's covenants and clause 2 of the lesser's covenant in the operative part of the principal lease and the order of 22nd May 2003, that is of Justice Ghosh, made in such and such, shall stand amended, modified as read hereunder. So Justice Ghosh's order again stood modified.
Modified to the extent mentioned
here.
Mentioned in this lease.
Here, of course. Monthly, the lessee's covenants to pay to the lessor monthly occupational charges at the rate of rupees 3.50 lakhs only per English calendar month with effect from 1st April 2008 to 31st March 2013. That is another 5 years. And pay monthly rent at 4 lakhs from 1st April 2013. And thereafter, the monthly rent shall be increased by 12% every 5 years till the expiry of the lease. So, my lord, the change that took place is Justice Ghosh's order enhanced the rent and said that if you don't pay the rent, if there is a defaulter, or defaulter clause to the defense would be struck off. Here, my lord, it says it further increased the deed of lease and thereafter it says that the lessee shall pay rupees 10 lakh as premium. This is an additional payment I was asked to make. না আরেকটা ছিল না যেটা এভিকশন হবে না কিন্তু ও হ্যাঁ ওই এক্সটেন্ডেড এইটা এক্সটেন্ডেড পিরিয়ডটা পাবো না So the premium was enhanced. The lessee shall deposit 10 lakhs with the joint receivers free of interest as security deposit for due completion of the construction of the building. And the joint receiver shall refund this security deposit of 10 lakhs without interest to the lessee upon production of completion certificate. And kindly note, my lord, this is very important. And if the lessee defaults, makes default in completion of the construction within the stipulated period as indicated in the order of 21st May 2009, then the security deposit of 10 lakhs shall stand forfeited to the joint receivers. This was the consequence that was agreed. So you will have to complete construction within another 5 years from 2030 and give a completion certificate. If you don't give a completion certificate, then your 10 lakhs will stand forfeited. It is not a breach anymore, for which you will have to suffer eviction. The consequence is penal.
No, that will go. So for that.
That 10 lakhs will go. So that original ground in that lease of 1985 is no more there today. The lessee has completed demolition of the remaining portion of the demised premises and has removed the debris. Within 5 years from 2009, the date of the lessee shall complete the construction of the new building on the demised premises up to optimum height. This is, my lord, what he will do. Then, C is very important, my lord. Suit number 574 of 1985. This is the present suit. Filed by the lessors against the lessee shall stand adjourned for 5 years from 21st May 2009. That is the date of the order. And if the lessee makes default in compliance with the order of May 2009, then the defense taken by the lessee in suit 574 of 85 shall be struck off, and the suit shall be transferred to the list of undefended suit for an ex parte decree. Then, if the lessee completes the construction of the new building on the demised premises within 5 years from the date of the order of the Honorable High Court of 21st May 2009, and complies with the directions given by the High Court in the order in the said order, then the lessor shall get the said suit 574/1985 struck out on expiry of 5 years from the date of the order, subject to payment of all costs incurred by the receivers in connection with the suit. Save as modified by these presents, all the previous powers, covenants, such and such, shall continue to remain applicable along with the covenant. And it is further ordered, recorded at the time of execution and registration of this presence, lessee has complied with the directions of the Honorable High Court of 2009 made in such and such. Lessee has completed the demolition of the structure. The lessee has obtained a building plan. Lessee has paid to the joint receiver the following amounts. Lessee has commenced construction of the new building on the demised premises as such and such. As the lessee in terms of the order of 21st May 2009 started construction of the new building within time on the demised premises as per the sanctioned building plan, after serving notice to the KMC on 12th of November 2009 under Rule 21, there will be option for renewal of the lease by the lessee for a further period of 19 years after 49, with effect from 1st April 2029 as stipulated under the deed of lease. So, my lord, that right which that 2003 order took away, that you won't have the right to get a fresh 19 years of lease, has again been brought back. So the final lease as it stands
1st April 2029.
Yes. 49 years, first 49 years is expiring in 29, and I will get a right of renewal for another 19 years. Now, my lord, construction has been completed within these 5 years.
It is still under your possession.
It is in possession of somebody. Kindly, my lord, now come to page 79.
Yes, was the original agreement entered with you and the plaintiff in terms of any permission granted by this court that they wanted to enter into a development agreement? Original, there was an order.
Original, there was an order of 77 of Justice Shoposachi Mukherjee permitting him to
enter into this development agreement.
Entering into an agreement for lease because there was Devotto. And thereafter, my lord, That lease was a building lease for construction of building.
So that lease is converted to a development agreement.
No, we entered into a development agreement. We entered into that
in 85.
In no, 83.
83.
No, this is no.
Original principal lease.
No, principal lease of 83. This agreement of development is in September 2007. The one is here page
2007. No, initial suit is in 85.
Suit is in 85.
The agreement is in 80. Original agreement between you and the plaintiff.
83.
83. Suit is in 85. And the permission granted by the court to enter into a lease agreement for development of the Devattur property or for the expenditure of the
letting it out for construction.
Yes, so that is in 1977.
77. That is referred to in one of the leases also, Millard, that the court had granted the Shebaites the permission to enter into that lease. So, Millard, I am on a very, very limited
Yes.
So, Millard, thereafter, Millard, in 2007, I entered into this development agreement with a promoter, Akriti developer.
During pendency of the suit?
Yes, Millard, during pendency of the suit.
And which the plaintiff was a party?
This Millard, the plaintiff won't be a
Plaintiff was not a party.
It was my obligation to construct.
So you engaged a developer.
The developer has constructed. The developer had the right to sublet. Developer has
Yes, instead of taking the responsibility on your shoulder, you assigned it to this developer.
And that right I had under the original lease also. So, Millard, today the question is very limited. My learned friend today is asking for your lordship's consideration as to whether this man is entitled to pay rent. Millard, if I am in occupation under a lease, I am liable to pay rent. Question is, if I am a defaulter, then Millard, your lordship will have to fall back on the four corners of the plane to pass an interim order.
So one thing is this, now you are no more in possession, the entire project is completed and handed over, that is one aspect. The other is, yes, you may be in possession, but there is no such breach.
There is no such breach as complete is the plane today.
That is another factual issue, that there is no such breach. And the other is this, yes, you are no more in possession, so why you should pay the rent.
Millard, I had repeatedly requested the court, Millard, that Lordship Millard, how did if things were, if I was in defaulter in 1985, if I was a defaulter in 1985, then my learned friend's prayer in this application is for payment of rent for the period. Master Samusta dena. Kindly see the master summons.
Master summons.
Forget the amount. The amount is disputed, but kindly see the period. December 2019 till February 2025. Is it within the scope of the suit?
Yes.
And even if, for argument's sake, I have not paid this amount, can he ask for payment of this amount in this suit? So, my lord, for the purpose of, if I admit, for the argument's sake, I admit that I am a defaulter, he can't rely upon a notice which says that the default is from September 85 to December 85. That is the scope of the suit. So even if I am in breach, the subsequent, he has to give me another notice under 111 saying that now you are in breach. The law does not say that you file a suit and all subsequent breaches, the court will have the jurisdiction to go on passing orders.
No, that is one thing you see. There is no question of any breach. You see, had it been a landlord-tenant suit, eviction suit or suit for eviction of the lessee, during the pendency of the suit, the defendant was to pay the rent.
Correct.
Maybe the default was for 2 years, 2 months previous.
Yes.
During the pendency of the suit,
I go on paying.
the defendant has defaulted.
Yes, but the thing is this, my lord, that breach in that suit stood waived by the subsequent deeds. The parties have entered into subsequent leases.
You see, that is another thing. You see, whether
So the breach did not survive.
Whether the suit has become infructuous, that is another question. Whether the suit has become infructuous.
Yes. My lord, that is why, my lord, the division bench said that if from the reading of the plaint it appears that the reliefs claimed in the plaint cannot be granted anymore.
Yes.
That is a question of lack of jurisdiction. I am not saying my learned friends today do not have the right to file a fresh suit. He may file a fresh suit, we'll defend it. But he cannot drag on a suit of 1985 where the limited period is your default for September to December and you have committed breach for not completing construction within 5 years in 1985. When the subsequent conduct shows that the parties themselves have extended the time and the breach stood waived.
Is a question if you see, when part of the relief claim is waived or met or complied, whatever it is, then the suit is satisfied. If the relief claim is satisfied or complied or settled, then
the cause of action merges.
So that's a different issue, whether anything remains in the suit to be decided.
Milord, with respect, Milord, on a plain reading of the plaint and the plain reading of the prayers, would your lordship find that there is any connection? I was a defaulter from 85 to September 85. The amount of default was 1,40,000. Thereafter, both parties came to court. They asked for an enhancement of the rent. It was enhanced. Rent was paid. Thereafter, they again approached the court. Again, the rent was enhanced. A fresh modified lease was executed. The enhanced rent was paid and accepted till 2019.
Time to time, there was terms of settlement entered into during the pendency of the suit, due time to time.
So, Milord,
now if nothing remains in the suit to be decided, whether this interlocutory, if the suit goes, the interlocutory applications cannot be disposed of.
And that was the point.
Suit should be disposed of or not by this court.
At this time, Milord, the Supreme Court has said that the court so desires can proceed with the suit. But Milord, I have taken your lordship through the plaint. In a suit for eviction, the plaintiff will have to prove the breach. The breach is not even part of the plaint today. There cannot be a breach because subsequently there has been waiver of the cause of action in the plaint. Parties have gone miles away. Many a water has flown down the Ganges. And it is not of my part. It is the action of both the lessor and the lessee. So, Milord, this cause of action on the basis of which the suit stands today, in my respectful submission, did not survive. And it is for this reason, Milord, when GS6 was filed, asking me to go on paying this rent, I had the opportunity, Milord, to address the court that to show that nothing remains in the suit. So how can you pass a direction?
Although you are paid up to 2019.
You've gone on paying. So that's the usual landlord-lessor-lessee relationship. I'll have another.
You are in occupation of the property, you went on paying.
I went on paying. In fact,
had there been no settlement, okay. For example, there was no terms of settlement.
Then that's one different.
Then you see,
Then it would be a continuing cause of
the
action.
earlier cause of action, and this is your obligation.
If during the continuance of the suit I am in defaulted, then that would have been different.
Now the question is whether at present anything remains to be decided in the
Yes,
suit. In
that-
that case, whether any interim order should be passed.
Yes, that is the only limited scope of GA9. Now, my lord, when GA6 was filed, this we tried to meet this argument by taking out GS8. In the meantime, the person who is in occupation Akriti, who is in possession of various persons, they came and filed an application for addition of parties. Now, that application got dismissed because nobody was appearing. GA8 was dismissed on the ground that this is not an Order 7 Rule 11 case simpliciter. Because I have to look into the subsequent leases which are not part of the plaint.
Yes.
So there the court was right, because the subsequent facts which on the basis of which I was arguing that the suit no more survives, could not have been gone into in an Order 7 Rule 11 stage. The appeal court said very well, then you can do it under Order 14. So the exercise now can be done under Order 14. In the meantime, they preferred an appeal before the Supreme Court. And the very important thing is, the Supreme Court's first line is, we do not want to interfere with the order passed by the appeal court. So that gives the stamp of approval that there is an issue as to whether the suit survives.
Yes.
And gave the court the liberty in that same order to decide. Now, my learned friend is now saying that it was also given a liberty to apply. Yes, you have a right to apply. For that, you don't need the liberty of the Supreme Court. Law gives you that right. But it has to be a subsequent fact.
But whether that application can be adjudicated without going into the preliminary issue, that is the question.
That will remain untouched. And Millard, I must say so, and I'll show you, Lordship, on the next occasion, that this same prayer, which is GA9, was also the subject matter of an interlocutory application before the Supreme Court. They made the same prayer.
Anyway, there is no observation. If the entire issue is decided, all interlocutory application stands disposed.
Yes.
So without any observation. So continue on 17th?
Yes, Millard.
Because I have a division bench.
Yes, yes.
17th at 2 p.m. to conclude, and if you want to file written notes, you can.
Millard, I will indicate a very short list of dates, because one order is in petition, two orders is in opposition. So I'll try and make a list of dates so that
it can be concluded on 17th. Yes. Learned advocates for the learned, Mr. Paul Learned, counsel for the plaintiff, and Mr. Dotto, learned counsel for the defendant, submits their arguments. However, the hearing cannot be concluded. Hearing of arguments cannot be concluded. Thus, 17/6/2025 be fixed for conclusion of the hearing of the arguments. Let this matter appear on 17/6/2025 at 2 p.m.
Today is the date for filing the notes of argument. In that matter, the permission to sue against the receiver.
Okay, file it.
May I file before your lordship?
এই যেগুলো ফাইল হয়ে গেল, এই নোটস অফ আর্গুমেন্টস গুলো একটু পাঠিয়ে দেবেন, যে সকালে একটা ফাইল হয়েছে, এটা এখন ফাইল হবে। হ্যাঁ, দুটো নোটস অফ আর্গুমেন্টস পাঠিয়ে দেবেন। সকালের দিকে একটা ফাইল করেছে, আর এখনো ফাইল করবে।
The same matter, which has been, the other side has filed in the morning.
Okay, 17th at 2 p.m.
Which